To Baiju's exam prep. In the last class, we initiated a discussion on Prime Minister and the Council of Ministers. And we are discussing Union Executive. Who all are part of Union Executive? President, Vice President, Prime Minister, Council of Ministers, and the Attorney General for India. We have discussed the office of President and Vice President, although not completely because we will revisit these offices when we will discuss Union Legislature. Then we looked at office of the Prime Minister and the Council of Ministers. And what does that mean? We follow a parliamentary form of government where cabinet, Council of Ministers, they are the real power holders as against the president. Whatever advice is given by Prime Minister and the Council of Ministers to the president, that is binding on the president. The first step is choosing the Prime Minister. Once the elections are over, then the first step becomes choosing the Prime Minister. And this is where we say there is an element of discretion available with the president. The president can appoint anybody as the Prime Minister. But then this Prime Minister has to prove majority on the floor of Lok Sabha. Because what is parliamentary form of government? The Council of Ministers, they are accountable to, they are responsible to the lower house of Indian Parliament, which is the Lok Sabha. And then we discussed that there is some difference between Council of Ministers and the Cabinet. And what is that difference? Minister of Home Affairs and Minister of State. I told you, if we look at a superset and we call it Council of Ministers, within this Council of Ministers, we have a subset known as Cabinet. 18 to 20 are the Cabinet Ministers, those who are in charge of the entire ministry. But within ministry, there are various departments, or there may be various departments. Those who are in charge of one or more departments within the ministry, we call them Minister of State. For example, who is the Minister of Home Affairs? Mr. Amit Shah. Mr. Amit Shah is the Cabinet Minister. Why? Because he is in charge of the entire ministry, entire home ministry. But within Ministry of Home Affairs, there are various departments. And I gave you the names of those departments: Department of Home, Department of Official Language, Department of States, Department of Internal Security, Border Management, Jammu and Kashmir and Ladakh Affairs. Now, if there is an individual minister who is part of Council of Ministry, on the advice of the Prime Minister, appointed by the President, if he or she is in charge of one or more departments within the ministry, we call him Minister of State. For example, Mr. A.K. Mishra. For example, Mr. Nishit Pramanik. For example, Mr. Nityanand Rai. Who are these individuals? They are also part of Council of Ministers, but they do not head the entire ministry. They are in charge of one or more departments within the ministry. And then these individuals, they report to the Cabinet Minister. So we call them Minister of State. Now let's imagine two situations here. Situation number one. Let's say in Ministry of Home Affairs, we have 6 departments. And there is one department known as Department of Internal Security. Listen to me carefully. What if tomorrow, on the advice of the Prime Minister, the President is appointing me as a minister? But who has the responsibility of allocating ministries to various individuals? That's the prerogative of the Prime Minister. Prime Minister gets to decide who becomes my Home Minister, who becomes my External Affairs Minister, who becomes my Defense Minister, who becomes the other ministers. Right? Now, what if Prime Minister decides that you will not head the entire ministry? You will be in charge of only this department, Department of Internal Security. But you will handle this Department of Internal Security independently. What does that mean, handling this Department of Internal Security independently? That means without me reporting to the Cabinet Minister. I will not report to the Cabinet Minister, because although Ministry of Home Affairs, they have these departments. Cabinet Minister, Mr. Amit Shah, is in charge of all these departments. But one department, I am told, you handle independently, you don't have to report to the Cabinet Minister. I become Minister of State with independent charge. I am a Minister of State because I am in charge of one department within the ministry. But I am in charge of this department independently without having to report to the Cabinet Minister. I become Minister of State with independent charge. That's scenario number one. Scenario number two. Let's say we have Ministry of Power. That is one ministry. But there is a junior MP, young promising MP, who is being asked, you take care of this department. You take care of this department, but you will not become the Cabinet Minister. You will become Minister of State with independent charge. Why? Because we want to first groom you so that you are independently able to control the entire department, entire ministry. For example, in the Dr. Manmohan Singh government, we had Jyotiraditya Scindia. Prior to that, we had Sachin Pilot. Young, promising leaders. They were given entire ministry, but they were told that you are not a cabinet minister. You are a Minister of State with independent charge. Basically, you will directly report to the Prime Minister. Prime Minister will handhold you, teach you all the nuances of this ministry, and once you are ready, we will make you a cabinet minister. That's scenario number two. Scenario number three. Who has the prerogative of allocating ministries to various individuals? Prime Minister. Now, I, as a Prime Minister, I am also a minister for some departments. That is why when you look at the list of cabinet ministers, the list of council of ministers, you will see that the first name would be Prime Minister. Prime Minister is in charge of all these departments, and those departments which are not allocated to any other ministry. Then you will have Defense Minister, Home Minister, External Affairs Minister, Finance Minister, so on and so forth. Now imagine a situation that I am the Prime Minister, but I am also a minister for DOPT, Department of Personnel and Training. I am also in charge of Department of Atomic Energy. I am also in charge of Department of Space. I am also in charge of Department of Northeastern, Ministry of Northeastern Region. We have had Prime Minister, for example, Indira Gandhi, she was the Prime Minister, but she was also the External Affairs Minister. Pandit Nehru was the Prime Minister, but once he was the External Affairs Minister as well. Dr. Manmohan Singh was the Prime Minister, but he was the Coal Minister as well. So it is possible, and it does happen, that Prime Minister is not only the Prime Minister, but he also directly is in charge of various ministries or departments. Today, Prime Minister Modi is also the Minister of Northeastern Region. There is a department known as Northeastern Region. He is also a minister of that. But there should be some minister who would assist the Prime Minister. Just like there are these ministers of state who assist the cabinet minister. In the similar fashion, if I am the Prime Minister, I am in charge of a department, there may be a minister who will assist me in handling this department. We call such a minister also as Minister of State with independent charge. Why? Because this Minister of State is independently in charge of that department. That means independent of the cabinet minister. There is no cabinet minister above the Minister of State with independent charge. Because this Minister of State with independent charge directly reports to the Prime Minister. And this term, Council of Ministers, includes cabinet ministers, include ministers of state, include ministers of state with independent charge. all these different types of ministers appointed by the president only on the advice of the prime minister. We call them council of ministers. But within council of ministers, there are those ministers who head the entire ministry. We call them cabinet ministers. And it is this cabinet, they meet regularly. That is why you might have read in the newspapers, Union Cabinet is meeting tomorrow. Union Cabinet meets. Union Cabinet decides to give 6% DA to central government employees. Union Cabinet has decided to ban the export of pulses. Union Cabinet has given a go ahead for FDI. Union Cabinet has done this, Union Cabinet has done that. It means it is basically the Prime Minister and all those ministers who head the entire ministry. They meet regularly and they decide the policies of the government, because Prime Minister alone cannot decide that. Prime Minister is just like any other minister. Prime Minister is also a minister. But Prime Minister, together with all the cabinet colleagues, they discuss the important matters. They meet regularly. And once they meet regularly, they will then inform their colleagues as well. They will then inform their deputies as well. They will inform their ministers of state as well. But ultimately, that is what we call the cabinet form of government, because it is these ministers who take the policy decisions. Clear? Then we have, the year was 2021, July to be precise, when a new ministry, Ministry of Cooperation, was created. And I told you last time that to create a new ministry, you don't need a constitutional amendment. Why? Because Constitution does not talk about ministries. Constitution only says that the executive power is vested in the president, and president will issue rules how to exercise these executive powers. And president has issued rules that these are going to be my ministries and they will perform my executive function. So if tomorrow another ministry is to be created, or a ministry is to be deleted, or a ministry is to be renamed, for that you don't need a constitutional amendment. You just have to change the rules, the allocation of business rules, as I told you last time, of 1961. For example, previously we used to have a ministry known as HRD ministry, Human Resources Development Ministry. When Mr. Modi came to power, the rules were changed, amended, and this ministry was renamed as Ministry of Education. So whether a ministry is to be created, whether a ministry is to be deleted, for example, previously we used to have Minister for Overseas Citizens, which used to be under External Affairs Minister. That department was also deleted. So a department can be deleted, a ministry can be deleted, a ministry can be created, a ministry can be renamed. For that, no constitutional amendment is required. But you will need more ministers, and that cannot exceed 15% of the Lok Sabha. The number of ministers, including the Prime Minister, which means the number of cabinet ministers plus ministers of state plus ministers of state with independent charge plus the Prime Minister, this total number shall not exceed 15% of the Lok Sabha. Okay? Then there is something known as kitchen cabinet. What is kitchen? Where the food is cooked. What is kitchen cabinet? Where policies are cooked. Imagine a situation that you're working in an organization, and in your organization, in your department specifically, there are 50 members. For example, in your team, there are 50 members. And then you have a manager. Does manager consult all these 50 people whenever a decision is to be taken? Not necessarily. But this manager will have a select group of people who will be the eyes and ears of this manager. Basically, the manager will rely on these 4 or 5 people for their advice, for their counsel, for their suggestions. Similarly, Prime Minister and the entire cabinet, they have to take a decision. Instead, what exactly happens in practice, there is Prime Minister, and then the Prime Minister has few important colleagues. It is basically this Prime Minister and this setup, this group of 4 or 5 people, it's basically they taking the decision. They are basically cooking policies. And then once the policies are cooked, these policies are taken before the cabinet, which is just a mere formality. This group of people who are very close to the Prime Minister, that is what we call kitchen cabinet. For example, Pandit Nehru, his kitchen cabinet consisted of Maulana Azad, Sardar Patel. They were part of the kitchen cabinet. When Mr. Vajpayee was the Prime Minister, Mr. Vajpayee, L.K. Advani, Murli Manohar Joshi, the Minister from Maharashtra, Pramod Mahajan, these were very important individuals. So basically, it was Mr. Vajpayee and a set of 3 or 4 individuals. They were taking all the decisions. And once they were taking the decisions, ultimately the matter was given to the cabinet. You just give the approval. Similarly, today, Mr. Modi will have strong dependence on Mr. Amit Shah, Mr. Bhupendra Yadav, other 1 or 2 more individuals. They together take a decision. But since the final decision is to be taken by the cabinet, because we are a cabinet form of government, whatever decision government will have to take, that has to be taken in this cabinet meeting. If there is no consensus in the cabinet meeting, ultimately voting has to take place. And whichever way majority is, that is going to be the decision of the government. So imagine a situation that Prime Minister, Mr. Amit Shah, Mr. Ajit Doval, and few other individuals, for example, Bhupendra Yadav, all these individuals were aware what is going to happen to Jammu and Kashmir on August 5, 2019. They know that we are going to revoke the special status of Jammu and Kashmir. We are going to introduce a bill in the parliament to reorganize Jammu and Kashmir into union territories. Clear? So they had taken the decision. This is where the policy was already cooked, that this is going to be our policy vis-a-vis Jammu and Kashmir. But they cannot take a decision. Ultimately, the decision is to be taken by the cabinet. Cabinet has to give its approval that yes, we will recommend the president, please withdraw the special status for Jammu and Kashmir. We have to give the permission. Yes, this Jammu and Kashmir reorganization bill should be passed by the parliament. We will ask the president, please give us the permission to introduce this bill in the parliament. So basically, the decision ultimately has to be taken by the cabinet, but it is only a mere formality because policy has already been cooked. That is why on 5th of August 2019, when cabinet meeting took place, everybody said, yes, we agree with this decision. That was although the policy was cooked, but just a formality was taken in this cabinet meeting, and then the go-ahead was taken. That is what we call kitchen cabinet, but it is an informal body, not mentioned in the constitution, not mentioned in the rules as well. Informal body. That means it is the experts, those who watch how the government functions. They claim that Prime Minister relies on certain set of people, and they call those certain set of people, including the Prime Minister, as kitchen cabinet, where the real policy is cooked. Although this term kitchen cabinet is not mentioned in the constitution, it's not mentioned in the rules as well, it's an informal body. Done? Then we have something called cabinet committees. And what are these cabinet committees? Sir, what happens if the bill is accepted by cabinet but not the Council of Ministers? Council of Ministers have no role here. It is the cabinet minister, because if I am the cabinet minister, whatever I decide, that is going to be accepted by my colleagues as well, those who are assisting me, my ministers of state. So they don't have individual powers. Whatever is decided by the cabinet, that is going to be the policy of the government. Now, you tell me, what is the difference between an individual decision and a collective decision? Individual decisions are quick. If I get to decide, let's have FDI in multi-brand retail, 100% FDI in multi-brand retail. If this is my individual decision, it will be quick. But what if we have to take a collective decision? It may be delayed. Delayed in the sense, if all the ministers will have to come together and then decide whether FDI in multi-brand retail should be allowed or not, up to 100%. Two ministers will have their own viewpoint, three ministers will have their own viewpoint, I will have my own viewpoint, and ultimately we will debate, discuss, and finally decision would be delayed. Decision will be taken, but it will be delayed. Otherwise, in an individual capacity, I can take a quick decision. But this quick decision may also be hasty, may not be a good decision. Collective decision may be a deliberative decision. Collective decision may be a thoughtful decision and may be a good decision in the interest of the country. So what would you prefer? An individual decision or a collective decision? And from this idea came the idea of cabinet committees. Today, we say we live in a globalized world. Globalized world in the sense, if there was a war, if there is a war between Russia and Ukraine, that has an impact on India as well, because of the increase in the crude oil prices, because of the breaks in the supply side chains. Similarly, if there is a conflict in any part of the world, that is going to affect another part of the world. We live in a globalized world. And in this globalized world, any decision that we take will have impact at multiple levels, across multiple functions. For example, there is food inflation in India. What is food inflation? A rise in the general prices of the food commodities. For example, tomato prices are at 300 rupees per kg. Onion prices are at 500 rupees per kg. Food inflation, that means rise in the general price level of essential food commodities. Now, how would I tackle this food prices? If I am the agriculture minister, I will say, let's ban the export of onions and tomatoes. We will not export onions and tomatoes. In fact, we will import onions and tomatoes at lower prices so that we distribute this in the market. Ultimately, the supply increases and the price will come down, because it's all about demand and supply. But I cannot take this individual decision, because if I start banning the export of onions and tomatoes, that is going to affect Bangladesh. And it did affect Bangladesh when we banned the export of onions some time ago because of the rising food inflation. And Bangladesh will protest. Why? Because you have supplied us with a shock. You should have informed us beforehand that we are going to ban the export of onions. We would have taken other measures. We would have asked some other country, including Pakistan, to supply us onions. Because in our market now, there is food inflation. And Bangladesh will protest in presence of external affairs minister. So an external affairs minister should also be involved in this decision. Finance minister should also be involved in this decision, because it involves financial cost. When you are saying that I will import onions and tomatoes from outside, that means you don't have to import, you don't have to impose duty on them. That is going to affect the finances of this country. So every decision that we take will have an impact across multiple ministries. This is where the idea came. Let's have cabinet committees. Instead of one minister taking a decision on some matters, let's involve a group of ministers so that they can take a decision. Cabinet committees are extra constitutional bodies. That means cabinet committees are not mentioned in the constitution, but they are mentioned in the rules of business. When rules of business, which mentions various ministries, various departments, these rules of business, they also mention cabinet committees. And cabinet committees can be of two types, either standing or ad hoc. Standing in the sense permanent, standing in the sense for a long time. Ad hoc means for a temporary purpose. For example, in 1962, when there was a war between India and China, a cabinet committee on war was constituted. It was an ad hoc cabinet committee. So basically, the job of this cabinet committee was to take a look at what is happening along this war between India and China. What are the steps that we have to take so that together they can report to the Prime Minister, they can report to the Parliament. So, cabinet committee can be either standing, which means it is for a long duration, or it can be ad hoc, that means for a specific purpose. And once that purpose is solved, then this cabinet committee is dissolved. When Dr. Manmohan Singh was the Prime Minister, there used to be 13 cabinet committees. Then came Mr. Modi, he said, why 13? We will have 6 cabinet committees between 2014 to 2019. Then in 2019, Mr. Modi said, we will have 2 more cabinet committees, which means what is going to be the strength, what is going to be the number of these cabinet committees, that's the prerogative of Prime Minister. And today we have 8 cabinet committees. And in all these 8 cabinet committees, what should be your focus? How many cabinet committees do we have? Who heads that specific cabinet committee? Is Prime Minister part of that cabinet committee? What is the purpose of that cabinet committee? These are the only 4 things that you have to keep in mind. How many cabinet committees do we have? 8. Which are these 8 cabinet committees? Let's discuss. Who is the chairperson of this cabinet committee? If Prime Minister is a member of this cabinet committee, Prime Minister becomes the chairperson of this committee. But if Prime Minister is not a member of this cabinet committee, then who is the chairperson of that committee? That you will have to identify. And also, what is going to be the purpose of this cabinet committee? The first cabinet committee we have, Appointments Committee of the Cabinet. And there are 2 members of this cabinet committee, the Prime Minister, who is the chairperson of this committee, and the Home Minister, Mr. Amit Shah. What is the purpose? We have to appoint a secretary to a government department. For example, who is going to be secretary of Department of Economic Affairs? Who is going to be the secretary of Department of Expenditure? Who is going to be the secretary of Home? Who is going to be the Home Secretary? Who is going to be the Cabinet Secretary? Who is going to be the Foreign Secretary? All these appointments at the central level of Joint Secretary and above, that is decided by this committee known as the Appointments Committee of the Cabinet, which is headed by the Prime Minister, and Home Minister is the other minister. Who is going to be appointed as, let's say, the chairperson of a public sector undertaking? That this committee also decides. Who is going to be the head of the Prasar Bharati? That this appointments committee will have to decide. So all the appointments, important appointments at the central level, appointment of bureaucrats at the central level, of Joint Secretary and above, that is decided collectively by Prime Minister and Home Minister in this meeting, in this committee known as the Appointments Committee of the Cabinet. Clear? Then we have Cabinet Committee on Accommodation. For example, whether Mr. Raghav Chadha will stay in that bungalow or not, or whether some other bungalow will be allocated to him. Shrimati Sonia Gandhi, whether you will stay in that bungalow or some other accommodation will be provided to you. Rahul Gandhi was no longer a member of the parliament. Now you will have to vacate the Tughlaq Road flat or bungalow that was allocated to you. Shrimati Priyanka Gandhi Vadra, now that you are not protected by the SPG, the Special Protection Group, You don't need such a massive property, you'll have to vacate. So all these ministers at the central level, all the MPs at the central level, all the judges of the Supreme Court, all the important constitutional functionaries, Mr. Ramnath Kovind, now you are no longer the president, we'll have to give you a suitable accommodation in Delhi. All these decisions are taken by a cabinet committee on accommodation, but you would know that this is a trivial matter. Why should Prime Minister get involved into this? Who gets which bungalow, which flat? Why should the Prime Minister get involved in this? That is why Home Minister is part of this cabinet committee on accommodation. Home Minister is the chairperson of this committee. Clear? So one is cabinet committee on accommodation, which basically provides accommodation or lists accommodation for various constitutional functionaries. And then we have appointments committee of the cabinet. Then we have cabinet committee on economic affairs, which is headed by the prime minister. And there are various members of cabinet committee on economic affairs. But you don't have to remember the names of these members. Just focus on what is this cabinet committee on economic affairs. Who is the chairperson of this committee? Prime Minister, which means Prime Minister is a member of this committee. Who are the other members? Not important. What is the purpose of this cabinet committee? That we have to decide. What is the purpose of cabinet committee on economic affairs? For example, I gave you one example that if there is food inflation and then the government decides to ban the export of onions and tomatoes, the government decides to import onions and tomatoes, the government decides to abolish the import duty on various pulses or oil seeds. All these economic decisions are taken collectively by this cabinet committee on economic affairs. Whether there has to be or there should be FDI in multi-brand retail, in single brand retail, whether there should be FDI in insurance sector. Long story short, any economic decision which the government takes basically is taken by this cabinet committee on economic affairs. Then we have cabinet committee on parliamentary affairs. We will discuss today as well as day after tomorrow, because tomorrow we have a holiday. Celebrate my best wishes on Vijayadashmi. Who summons parliament? President. It is basically the power of the president that you summon parliament. Summon parliament means that today is going to be the winter session of the parliament. On these dates, we are going to have the monsoon session of the parliament. On these dates, we are going to have the budget session of the parliament. Who decides that? President of India. But president is a rubber stamp. Whatever decision is taken by the president, that is basically on the advice of the Council of Ministers. And in practice, it is on the advice of the Cabinet Committee on Parliamentary Affairs. When to summon legislature, all the government bills that need introduction. For example, the government decides tomorrow that we should amend the Unlawful Activities Act, or we will amend Prevention of Money Laundering Act, or we will amend all these important laws. This is going to be the government business. That means all these bills are going to be government bills. That means all these bills will be introduced by the minister, not the private member, but by the minister. Who decides this matter? Cabinet Committee on Parliamentary Affairs. Similarly, when Parliament is going to be summoned, for how many days Parliament should function, when the Parliament is going to be prorogued, when the session is going to be terminated, although that is decided by the President, but in reality, on the advice of the Council of Ministers, and in practice, on the advice of the Cabinet Committee on Parliamentary Affairs. Previously, this Cabinet Committee on Parliamentary Affairs used to be headed by the Home Minister Now it is headed by Defense Minister. That is what we call Cabinet Committee on Parliamentary Affairs. Then we have Cabinet Committee on Political Affairs. And the chairperson of this Cabinet Committee is the Prime Minister. And we call this Cabinet Committee on Political Affairs Super Cabinet. So if there is a question tomorrow in your prelims examination, which of the following cabinet committees is known as a super cabinet? A, B, C, D. You should know that the right answer is Cabinet Committee on Political Affairs. After all, political decisions are to be taken by the government. For this particular state, where the election is about to take place, this is going to be the policy of the government. This is decided in Cabinet Committee on Political Affairs meeting. For Telangana, we will announce these many schemes and these many policies, or we will announce a new IIT, a new IIM. All the political decisions that the government has to take is taken in this Cabinet Committee on Political Affairs. That is why we call it a super cabinet. It is headed by the Prime Minister, which means the chairperson is the Prime Minister. Who are the other members? You don't have to get into that. Just understand what is the concept behind this. Then we have Cabinet Committee on Security, consisting of the Prime Minister and 4 top ministers of the central government. Who are the 4 top ministers? Home Minister, Defense Minister, Finance Minister, External Affairs Minister. These 4 top ministers plus the Prime Minister, they are part of this committee known as Cabinet Committee on Security. And what is this Cabinet Committee on Security? Tomorrow, God forbid, if you believe in God, there is a bomb blast somewhere in India. Now we will have to review the situation. Was there an intelligence failure? Was there failure in the level of our preparedness? How do we prevent such attacks from occurring? For that, we need important steps to be taken. That is decided by Cabinet Committee on Security. Similarly, in Manipur, there is a crisis. We will extend Armed Forces Special Powers Act in Manipur again, decided by Cabinet Committee on Security. So all the decisions on the internal security are taken together by Prime Minister and 4 of his top ministers. That is what we call Cabinet Committee on Security. It has another role. All defense purchases above 1,000 crores need to be cleared by this committee. And this was also in the news for regarding the Rafale program, the Rafale deal between India and France, which supplies India with the Rafale jets. Opposition alleged that when Mr. Modi as the Prime Minister went on a visit to France, there he announced this deal between India and France, wherein under this agreement, India would get the Rafale jets. The opposition alleged that Prime Minister did not take Cabinet Committee on Security into consideration, because any defense purchase worth 1,000 crores or above, that has to be first cleared by the Cabinet Committee on Security. That means all these ministers plus the Prime Minister, they have to take a decision whether we should buy these Rafale jets from France or not. But whether that is true or not, we don't have to get into the politics of it. We just have to understand the polity of it. And for that, we need to know that there is Cabinet Committee on Security, headed by the Prime Minister, 4 top ministers. What is their job? The job is to review the security situation of this country. What is their purpose? The purpose is any defense purchase worth 1,000 crore or more should be approved by this Cabinet Committee on Security. These were the 6 cabinet committees which were in operation from 2014 to 2019. Cabinet Committee on Accommodation, Appointments Committee of the Cabinet, Cabinet Committee on Economic Affairs, Cabinet Committee on Parliamentary Affairs, Cabinet Committee on Political Affairs, and Cabinet Committee on Security. Then in 2019, Mr. Modi said we will have 2 more committees. Cabinet Committee on Investment and Growth, which will be headed by the Prime Minister, and Cabinet Committee on Employment and Skill Development, which will also be headed by the Prime Minister. What will be the job of these two cabinet committees? You may be also asked in your examination, which of the following cabinet committees were last ones to be constituted? Which of the following are the newly created cabinet committees? So you have to know it is the Cabinet Committee on Investment and Growth and Cabinet Committee on Employment and Skill Development. All these ministers, they will come together and decide what are the steps that we should take so that we can get more investment into India. And this investment will ultimately lead to growth. What are the steps that we have to take to ensure that we provide skill development to our youth? And once our youth becomes skilled, that will enhance their potential to be employed in the job market. All such steps, whether scholarships, all such steps, whether skill development, all such steps, whether policy interventions, whatever is to be taken, that will be decided by these two cabinet committees. And this completes our discussion on Prime Minister, Council of Ministers, and cabinet committees. But we will revisit the office of the Prime Minister and his Council of Ministers when we will discuss the Union Legislature. So basically, in Union Legislature, we will cover Union Executive and Union Legislature together. Now, the last thing that we have to discuss in Union Executive is the Attorney General for India under Article 76 of the Constitution, which means this Attorney General for India is a constitutional post. Can opposition party be included in the cabinet, sir? What do you think? If opposition is also included in the government, number one, opposition will not accept because they have to criticize the government. And why would government ask the opposition to be part of the cabinet? Then basically they have to share power with them. They fought against them for this power. Why would they include them for power? But yes, there have been instances where a member of the opposition was given a cabinet status, a minister of cabinet status, but they were not given the power. For example, when P.V. Narasimha Rao was the prime minister, one member of the opposition, Dr. Subramaniam Swamy, was given a cabinet minister status, basically to negotiate with WTO. But it is not that you become a minister, just a status of cabinet minister is given. What about deputy prime minister? Constitution does not talk about deputy prime minister. But there have been instances where deputy prime ministers were appointed. For example, Sardar Patel was a deputy prime minister. Shri Devi Lal was a deputy prime minister. Shri L.K. Advani was a deputy prime minister. So deputy prime ministers are also ministers. Lal Krishna Advani was a deputy prime minister, but he was also the home minister. So this is just to resolve the conflict. For example, if there are two claimants of prime ministership, you can make only one as the prime minister. So you make one as prime minister and you make the other as deputy prime minister so that both are happy. And you give this deputy prime minister an important cabinet position. Just like we have deputy chief minister. Mr. Siddaramaiah said, I am also the chief ministerial candidate. Mr. D.K. Shivakumar said, I am also a chief ministerial candidate and aspirant candidate. Now, Congress party won after a long time. They could not afford that we will antagonize one. So, Mr. Siddaramaiah, this is going to be your last chief ministership because you have crossed a certain age. You become the chief minister, but Mr. DKS, you will become the deputy chief minister. So, both are satisfied. What is the difference between kitchen cabinet and cabinet committee? Cabinet committee is a body which has recognition in the rules, the allocation of business rules. Kitchen cabinet is an informal body. It's not mentioned anywhere. It's not mentioned in the rules. We assume that Prime Minister and few of his ministers, it is they who take a decision, and we call them kitchen cabinet. Whenever a cabinet committee meeting is to be set up, for that a formal invitation is sent to cabinet ministers. Then whatever is decided and discussed in that cabinet committee meeting, all the minutes of the meeting are noted down, and you have the cabinet secretary, who is the topmost bureaucrat, who is also part of these meetings, and basically he notes down everything that we have mentioned, and then what is the action to be taken. So it is basically a formal setup. When cabinet meeting is called, when the meeting of cabinet committee is called, all that is done through invitation. First invitation will be sent, then you will have to attend, then whatever we are discussing, that is to be noted down. That's what we call the minutes of the meeting. Basically what this minister said, who opposed this decision, who was in favor of this decision, and ultimately whether this decision is to be taken or not, there will be voting. How many people were in favor, how many were against. All these meetings are formalized because all these decisions are noted down. But kitchen cabinet is an informal body, so it's not that a formal invitation is sent. Prime Minister will take out his phone and call these 2 3 ministers, come, let's have a cup of tea, or let's have a glass of wine, let's discuss. Not the current prime minister, previous prime ministers used to drink, and then on the cup of coffee they will get to decide what should we do for this particular matter. But nobody will write down what each of these individuals discussed, because it's an informal setup. That's the difference between the two. In what case these cabinet ministers are appointed? Educational qualification. Whoever is a member of parliament is eligible to be appointed as a minister. To become a member of the parliament, there are no educational qualifications. So there are no educational qualifications in order to become a minister. Sir, what is the ethics committee? Is that not standing committee? Please listen to me carefully. Right now, what are we talking about? Union executive. What you're talking about is part of union legislature. So in parliament also there are various committees. Parliamentary committee on law and justice, parliamentary standing committee on ethics, privileges committee of the parliament. What will happen to Mohua Moitra? We will discuss that, but in union legislature, because that pertains to parliament. Right now we are discussing union executive. Can a non-minister be part of kitchen cabinet? Logic. If it's an informal body, not mentioned anywhere, anybody can be part of the kitchen cabinet. Who are the deputy ministers? Deputy ministers used to be appointed previously, but now they are not appointed. For example, ministers have a lot of role to play. If I am home minister, for example, I have to ensure internal security of this country. I have to ensure that borders are also safe. Although when war breaks out, then it's taken over by the army, it's under defense ministry. But first I have to ensure that the borders are safe as well. So I have to take a lot of decisions. I have a lot of work to do. I have to ensure the security of the people. But at the same time, I am also accountable to the parliament. That means parliamentarians will ask me various questions inside the parliament. Questions like when NRC is to be carried out. Questions like how many citizens of India took the citizenship of foreign countries. How many renounced the citizenship of India. Now, when questions are asked to me in parliament, who is going to assist me in answering these questions? Deputy minister. That means I am the cabinet minister. I also have ministers of state. But minister of state, one minister of state will be in charge of Department of Internal Security. Another will be in charge of Department of States and Department of Official Language, 2 3 departments. That means they will assist me when I'm performing the duties related to my ministry. But who will assist me when I have to answer questions related to my ministry inside parliament? For that, I used to have a deputy minister. But now these deputy ministers have not been appointed. In fact, after 1975, these ministers have not been appointed. Although during the brief time during Rajiv Gandhi's prime ministership, some deputy ministers were appointed, but now they are no longer appointed. Do we have a deputy prime minister currently? No, we don't. To the office of the prime minister, one would become the prime minister, the other may be appointed as a deputy prime minister. And we say he is the highest law officer of the country. What is the role? The president has assigned to the Attorney General for India the duty to appear on behalf of the government of India in all cases in which government of India is concerned, and to represent government of India in any reference made by the president to the Supreme Court under Article 143 of the Constitution. Two things. Or I should say there are 3-4 important roles played by the Attorney General. Number one, representing the union government. Before the courts. What does that mean? You and me have a dispute, and I tell you I will see you in court. You are replying likewise. We go to the court. There will be my lawyer who will defend me in the court. There will be your lawyer who will defend you in the court. Simple. You know that. Now imagine a situation that I am now the state, the central government. Who is going to represent central government in various courts of this country when cases are filed against the central government? Attorney General for India. Should same-sex marriage be legalized or not? Notices were issued to the central government. You tell us whether same-sex marriages should be legalized or not. Who represented the central government? Attorney General for India. So there was Tushar Mehta as well, who is the Solicitor General. We will discuss his office as well, but slightly later. But first, Attorney General for India. How Article 370 was diluted. Whether Jammu and Kashmir reorganization bill is constitutional or not. A case is filed against the central government. Who will represent the central government before the court? The Attorney General for India. So role number one of the Attorney General is to represent the government of India in all cases where the government of India is a party, where a case has been filed by the central government, or where case has been filed against the central government. Who is going to represent the central union government? The Attorney General for India. Second, presidential reference under Article 143. What is presidential reference? Under Article 143 of the Constitution, which we will discuss in judiciary, Supreme Court is the advisor of the President of India. President can refer any matter to the Supreme Court, asking the views of the Supreme Court on that matter. But who is going to present the story, the side of the central government? Attorney General for India. Sir, what does that mean? We will discuss this in judiciary. In 1981, Supreme Court said it is the job of the government to decide who becomes the judge of the Supreme Court, judge of the High Court. But in 1993, the Supreme Court said no. We will have something known as the collegium system, where Chief Justice and some of his cabinet, some of his judicial colleagues, they will recommend names to the president, and only those names are to be appointed by the president for Supreme Court or High Court. That's how collegium system got developed. So we have two judgments. 1981 judgment, which says executive, president has the power to appoint the judges. 1993, the Supreme Court is saying, no, president will appoint, but only on the advice of only after consultation with the Supreme Court itself. Now there is a dispute. Executive is saying, why should we give up our power? Ultimately, a presidential reference was made. President referred this matter, how the judges are to be appointed, to the Supreme Court, asking the views of the Supreme Court on this matter. And this was in 1998. And then the Supreme Court will hear this presidential reference. That means Supreme Court judges will hear this matter which has been referred to it by the president to give its views. And what is this matter? Appointment of judges. Who is going to present the argument on behalf of the central government on this case? That individual also is the Attorney General for India. That means the role of the Attorney General is not only to defend the union government when a case is filed against it, or when union government files a case against somebody. The job of the Attorney General also is to represent or give the side of the story of the central government in any presidential reference made under Article 143. It has another role. Give legal advice to the government. What is that legal advice? The Prime Minister, Home Minister and others, they are discussing something important. We don't like Mamta Didi. Mamta Didi should go. Or we don't like Stalin. Stalin should go as the Chief Minister of Tamil Nadu. He is going to be a strong contender for the post of the Prime Ministership. If other political parties come together, Congress does not emerge so powerful, then this DMK headed by Mr. Stalin, it's going to command support of others. He will become the Prime Minister. So we want to dismiss him. We want to impose President's rule in Tamil Nadu and dismiss Mr. Stalin from the post of the Chief Minister, just like we dismissed his father, M. Karunanidhi, in the 1990s. But politicians, ministers, they are not legal advisors. Basically, they don't have the knowledge of the law, or they have a limited knowledge of the law. They will ask the Attorney General, please come, give us your advice. That can we dismiss the Chief Minister? And if we can't dismiss right now, under what circumstance can we dismiss the Chief Minister? The Attorney General would say, no, you cannot just dismiss the Chief Minister. You can dismiss the Chief Minister if there is breakdown of constitutional machinery. And these are the instances under which you can dismiss the Chief Minister. These are the instances under which you cannot dismiss the Chief Minister. So who is going to advise the government, the central government, on legal matters? That individual is also the Attorney General for India. And the fourth important role, which we have discussed previously, in criminal contempt cases, to provide sanction. For example, if you have to file a criminal contempt court case against somebody, for that what you have to do, you have to approach the Attorney General. If Attorney General gives you sanction, only then you can approach the court. These are the four broad roles, functions performed by the Attorney General for India. And that is why we call him the highest law officer in the country. But who is going to be appointed as the Attorney General? Clearly, a doctor cannot be, an engineer cannot be, it's going to be a lawyer. It's going to be somebody who knows the law, who can defend the central government. The president shall appoint a person who is qualified to be appointed as the judge of the Supreme Court. That means this person to be appointed as the Attorney General for India, he should not be the Supreme Court judge. Because if you are a Supreme Court judge, you cannot be appointed as the Attorney General. Because Attorney General is part of the executive. As Supreme Court judge, you are part of the judiciary. There is separation of powers between executive and judiciary. But only those who are qualified to be appointed as the Supreme Court judge, those individuals are qualified to be appointed as the Attorney General for India. What is the qualification for a Supreme Court judge? Number one, you should be the citizen of India. And judge of one or more high courts for 5 years. If not, then advocate of one or more high courts for 10 years. If not, in the eyes of the president, you should be a distinguished jurist. Who can be appointed as the Attorney General? First, we have to understand, is Attorney General a constitutional post? Yes, mentioned under Article 76. Is Attorney General part of the Union Executive? Yes, because Union Executive consists of President, Vice President, Prime Minister, Council of Ministers, and the Attorney General for India. What is the role of this Attorney General? Number one, we call him the Chief Law Officer of this country, or the topmost legal officer of this country. Why? Because he represents the government of India in all the cases where the government of India is a party. Second, he presents the view of the central government in all the presidential reference cases under Article 143. 3, to provide legal advice to the central government. 4, to provide sanction in criminal contempt court cases. But who is going to be this Attorney General? Number one, this person should be qualified to be appointed as the judge of the Supreme Court. You should not be the judge of the Supreme Court, because if you are a judge of the Supreme Court, you cannot be appointed. But you should be qualified to be appointed as the judge of the Supreme Court. What is the qualification? You have to be the citizen of India. If you are a citizen of India, then you have to meet one of these three criteria. You are a citizen of India, and at the same time, you are judge of one or more high courts for 5 years. You are qualified to be appointed as the Supreme Court judge. You are the citizen of India, and you are the advocate in one or more high courts for 10 years. You are qualified. You are a citizen of India, and in the eyes of the President of India, you are a distinguished jurist. You are qualified to be appointed as the Supreme Court judge. And if you meet this qualification, except the judge qualification, because a judge cannot be appointed as Attorney General, that means if you meet these two or any of these two criteria, you can be appointed as the Attorney General for India. What is distinguished jurist? Maybe President will say that, Mr. Sarmat, you're a citizen of India? Yes, sir. But you are not judge of one or more high courts. You have not been the judge of the high court for 5 years. No. You are not an advocate practicing in high courts for more than 10 years. No. But in my eyes, you are a distinguished jurist. You understand the law. You can be appointed as the Attorney General for India. Clear? And it shall be the duty of the Attorney General to give advice to the Government of India upon such legal matters, and to perform duties of legal character as may be from time to time referred or assigned to him by the President. Any other responsibility, any other legal responsibility can be assigned to the Attorney General by the President of India. Clear? Another one. The judges of the Supreme Court retire at the age of 65. But this age limit does not apply to the Attorney General. For example, we have Mr. Venkatramani as the Attorney General. He's in his 70s. Prior to him, we had Mr. K.K. Venugopal as the Attorney General for India. He was 93. That means age limit which is applied to a Supreme Court judge, that does not get applied to the Attorney General for India. So if we say you are qualified to be appointed as the Attorney General, if you are qualified to be appointed as the Supreme Court judge. But once you are appointed as the Supreme Court judge, you have to remain in office till the age of 65. Does that mean Attorney General can remain in office only till the age of 65? After that, you have to appoint someone else? No, this age limit does not apply. This Attorney General is not a member of the cabinet, but it is an integral part of executive machinery. Attorney General is not part of Union Cabinet because Union Cabinet consists of Prime Minister and his top ministers. So please don't confuse. Attorney General is not part of Union Cabinet. Attorney General is part of Union Executive. Union Executive consists of President, Vice President, Prime Minister, Council of Ministers, and Attorney General for India. And we say the Attorney General holds office during the pleasure of the President. That means appointed by the President, but no fixed tenure. Mr. Mukul Rohatgi was appointed as the Attorney General by the President of India on the advice of the Prime Minister. That means only on the advice of the Prime Minister, Attorney General can be appointed. But for how many days, how many months, how many years, this tenure is not mentioned in the Constitution. Tenure is decided by the President on the advice of the Prime Minister. So the advice was that appoint Mr. Mukul Rohatgi for 3 years. Mukul Rohatgi was appointed for 3 years. Can he be reappointed again? Yes. Can he resign before that? Yes. For example, Mr. Mukul Rohatgi, he submitted his resignation to the President. President accepted that resignation, and then Mr. K.K. Venugopal was appointed as the Attorney General. He resigned, submitted his resignation to the President, and then Mr. Venkatramani was appointed as the Attorney General. That means this tenure is not defined. That means at any point in time, the President can appoint you as the Attorney General, and the President can remove you as well on the advice of the Prime Minister. And that is what we call doctrine of pleasure. And what is going to be the salary, what is going to be the remuneration to be provided to Attorney General, that is also decided by the President of India on the advice of the Prime Minister and his Council of Ministers. And now you will understand it is on the advice of the Cabinet, not the entire Council of Ministers. Clear? The Attorney General has the right of audience in all courts in the territory of India. What is this right of audience? For example, there is a case going on in the Supreme Court, and the case involves Party A and Party B. Two parties, for example, you and me, we have a case in the Supreme Court. Now suddenly a third person walks in and tells the court, "Dear court, you please listen to my side of the story." The court will say, "Who are you? Are you connected in this case? Have you filed any application in this case? Who are you and why should we listen to you? Get out." But if this third person is the Attorney General, the court has to listen to him. Court has to give him audience. "Mr. Attorney General, you want to say something? Please come and tell us. What do you want to say?" He has a right. Maybe he has to say something which can tell us the position of the central government on this case. Even if there's a case going on in the Kerala High Court between two parties, and suddenly Attorney General walks into, the court has to listen to him. That is his privilege. And this is what we call the privilege of the Attorney General. The Attorney General has the right of audience. Whenever he walks inside a court, the court has to listen to him. Similarly, the Attorney General has the right, has a privilege to come and attend the proceedings of the Parliament, to sit in the Parliament, to speak in the Parliament, to become a member of any parliamentary committee as well, except he does not have a right to vote. Why? Because he's not a member of the Parliament. But the privilege is, despite the fact that you are not a member of the Parliament. What is a privilege? We say you are a privileged individual. That means you have access to a golf course. It's not something that you have earned on your own. It's because of your father that you have this privilege that you can access golf course. You can be a member of a club. That's not something that you have earned. It's because of your father, it's because of your mother, it's because of your ancestors. That's a privilege. Privilege is something that you don't earn on your own. Same is the case with the privileges available to the Attorney General. It's not something that Mr. Venkatramani has earned on his own. It's because of his office, Attorney General for India. that you have a privilege. Privilege is you are not a member of the parliament, yet you can attend the proceedings of the parliament. Yet you can speak in the parliament. Yet you can become the member of any parliamentary committee as well, except you don't have right to vote. Why? Because you are not a member of the parliament. You have all the privileges and immunities that are available to the members of the parliament. And we will discuss in Union Parliament chapter, Union Legislature chapter, what are these privileges, powers, and immunities that are available with the ministers, but that are available with the members of the parliament. But listen to me carefully. Who is this Attorney General who has to defend the central government in the Supreme Court or in a high court where a case against central government has been filed? Clear? So this individual has to be very talented. Clear? Why? Because if he's not talented, the government of India will lose the cases. Perfect? But this Attorney General will have to fight cases against some of the top lawyers of the country. Kapil Sibal is a top lawyer. Gopal Subramaniam is a top lawyer. Harish Salve is a top lawyer. Mahesh Jethmalani is a top lawyer. Mukul Rohatgi is a top lawyer. These are the top lawyers against whom this Attorney General will have to fight inside the court. And Mr. Harish Salve, he charges 40 lakh rupees per appearance. That means he just have to appear in a particular case one day, he charges 40 lakh rupees. But the salary of the president is 5 lakh rupees. So how can we give Attorney General this much amount of money? If tomorrow Harish Salve is appointed as the Attorney General, he will lose a lot of his money. Because he would get 40 lakhs per appearance. Even if he appears for 2 cases in a particular day, 80 lakh rupees. 80 lakh multiplied by 30, multiply by 365, and see the amount of money that these lawyers would be making. But when you appoint them as the Attorney General, you can't give them salary more than the president. That is why top lawyers would not agree to become the Attorney General, because they will lose out on money. Even if those lawyers who agree to become Attorney General, they become Attorney General for some time so that they can mention in their resume, we have been the Attorney General. But later they resign, they go back to their practice because that is where they earn the money. How do we ensure that we have the top lawyers who become the Attorney General and at the same time it is not a monetary loss to them? You allow them private practice. You can take up the cases of the central government as well. You can take up your private practice as well. Just like doctors. You can work in the government hospitals as well. Once the time is over, you can also practice at home. You can have your own clinic. You can work in a private hospital as well. Same is the case with the Attorney General. You can take up any private practice as well, if the opponent is not the state. If the opponent is not the union government. Because you have to represent union government in this particular case. You cannot represent a private person, a private party in this case, because you have to represent us. So a case in which the opponent is the state, you cannot take up that case as your private practice because you have to defend the state. But if the opponent is a state government, you can. For example, Mukul Rohatgi, when he was the Attorney General for India, he took up a private case as well. He took the case of Kerala Bar Association against the state government of Kerala. So is Kerala government a state? Yes. But it's not a union government. Because Mukul Rohatgi is appointed by the union government to defend union government. You cannot take up a private case where union government is one party. You can take up any other case involving any other party, any other state, any private entity. You cannot defend the accused in a criminal case without the permission of the government of India. What is a criminal case? I told you previously, a case involving an individual where the other side is the state. So if it's a criminal case of murder, If it's a criminal case of rape, you cannot defend the accused unless and until you take the permission of the government of India. Even if this is a case involving a state at a state level. But since it's a criminal case, you can't take this matter, you can't defend the accused without taking the permission of the central government. And he does not fall in the category of government servants. Tomorrow, once you become the IAS officer, IPS officer, you become a government servant, which means Prevention of Corruption Act will be applicable to you. But Attorney General is not a government servant, which basically means Prevention of Corruption Act will not be applicable on him. And to assist Attorney General, because Attorney General cannot be present in all the cases, we have the Solicitor General of India. And to assist them, we have a group of additional Solicitor Generals as well. But both these are extra constitutional offices. That means these offices are not mentioned in the Constitution. Attorney General's office is mentioned in the Constitution. But Attorney General cannot take up all the cases because there may be hundreds of cases filed against the central government. So to assist him, we have the Solicitor General who takes up the bulk of the cases. To assist them, we have additional Solicitor Generals who take up other cases. Those top cases are taken by Attorney General, and then some other important cases by the Solicitor General, and then smaller matters are taken by additional Solicitor Generals. This is Union Executive and Attorney General topic is over. Any questions, please let me know. The senior most law officer. Law officer are advocates, not judges. Cabinet as a term found mention due to 44th Constitutional Amendment Act 1978. Previously, this term was not mentioned in the Constitution. This we will discuss later. When national emergency was imposed in 1975, it was imposed on the grounds of internal disturbance. It is argued that the Prime Minister, Srimati Indira Gandhi, dialed the President, Fakhruddin Ali Ahmed, who was then in his bathtub, he was taking shower, and he was advised that please impose national emergency. And the thing is, Prime Minister did not consult the cabinet. Basically, the decision is to be taken by the cabinet, top ministers. So on the advice of the Prime Minister alone, that to the oral advice of the Prime Minister, the President imposed national emergency. And once national emergency was imposed, next day, the cabinet meeting was called by the Prime Minister. And in that meeting, the cabinet was told that there is no need to panic, but national emergency has been imposed. Then to prevent the misuse of Article 352, which deals with national emergency, the Janata Party, when it came to power, Constitution was amended, 44th Amendment was made, 1978, which said from now onwards, if national emergency is to be imposed, it should not be on the oral advice of the Prime Minister, it should be on the written advice of the cabinet. And that's how this term cabinet got added to the Constitution. Attorney General at the central level, that is the role of the Advocate General at the state level. Question, tell me. Parliament become an Attorney General? He won't be. But if you are, then as the member of the Parliament, you have the voting rights. That is an elitist thing to do. Educational qualification should not be there for politicians, should not be there for ministers. Why? Does that mean only formal education will make you empathetic to the problems of your constituency? Does that mean those who are not able to read and write, those who are illiterate, they will not be able to better represent your interest in the parliament? And the thing is, if I am illiterate, it is not my fault. It's the failure of the state in providing me educational opportunities. That is how I remained illiterate. Now, can you say, if this is not my problem, if this is not because of me that I'm illiterate, if it is not my fault that I'm illiterate, can I be punished for no fault of mine? Can I be punished for the failure of the state to provide me educational opportunities? And now the state is telling me, since you're not educated, you cannot become a minister. This is like an elitist concept. Something like it used to happen during the colonial period, where women were not allowed to vote. People with no access to money or no property were not allowed to vote. People who were not literate, they were not allowed to vote. So you are creating these classes in the society, which is against the principle of equality. Resignation. Attorney General is appointed for a term, although this term is not mentioned in the Constitution. But let's say the president says, I'm appointing you for 3 years. Once I complete 3 years, my term is over. Or I can be given extension. That means you continue for 1 more year. Or even before 3 years, I may be removed from my office by the president on the advice of the prime minister because of doctrine of pleasure. Or even before 3 years, I can submit my resignation. I will submit my resignation to the president and I will resign from my office. And whenever there is a change in the government, the normal practice is, the convention is, submit resignation when there is a change in government. I was appointed, let's say, G.E. Vahanvati. He was appointed as the Attorney General by the Dr. Manmohan Singh's government. On the advice of Dr. Manmohan Singh, the president appointed Mr. Vahanvati as the Attorney General. Now the government changed. Dr. Manmohan Singh is voted out of power. Now Mr. Modi comes to power. Mr. Vahanvati submitted his resignation. Although he was not bound to submit resignation, he was not required to submit resignation, but the convention is, unwritten rule is, since I was appointed by the previous government, now there's a change in the government, I will submit my resignation. If you want me to continue, you will tell me, no, I will not accept your resignation, you please continue. But if you will accept my resignation, that means you want to appoint someone else as the Attorney General. That is the convention that we follow. And we will take a break, and after the break, we will start with Union Legislature. Discuss the possible factors that inhibit India from enacting for its citizens a uniform civil code as provided for in the directive principles of the state policy. For every question, there has to be an introduction, there has to be body, there has to be conclusion. Conclusion should always be positive. Positive in the sense, let me give you a hypothetical question. What are the steps that you can take? What are the steps Parliament should take to prevent criminalization of politics? That's the question that the examiner is asking you to write. In your conclusion, you can't be pessimist. Although all these are good steps that the Parliament can take, but we are sure that Parliament will not take any such steps because Parliament does not have the intention to prevent criminalization of politics. You're being very pessimist. If there is a question on how can we solve the problem of corruption, you can't say that the Indians are by nature corrupt, so this problem of corruption will never get resolved. You're being very pessimist. UPSC will not give you marks because they need optimist people. So this conclusion has to be very positive. Stick to word limit. Don't cross the word limit and don't spend more than 7.5 minutes on a question. But then what is it that you will have to write? What is it that you'll have to skip? As much as possible, mention in point format. Point 1, 2, 3, 4. It will make the evaluation easier. And when you make the job of the evaluator easier, the evaluator will give you more marks. Discuss the possible factors that inhibit India from enacting for its citizens a uniform civil code as provided for in the directive principles of the state policy. Article 44 of the Constitution imposes a positive obligation on the state to strive for the enactment of a uniform civil code for all the citizens of India. This is your introduction. Now, you don't have to mention what is a criminal law, what is a civil law, how there is commonality in the criminal law, how there is no commonality in the civil laws, how, for example, we need to have more and more reforms in our personal laws. You don't have to mention that. You don't have to even mention the definition of uniform civil code. Why? Because that is not what the question is asking you. Discuss the possible factors that inhibit the state from enacting a uniform civil code. Because the examiner knows that you know what is a uniform civil code. Now, please tell me what are the factors that has prevented the state from enacting a uniform civil code. Number one, lack of consensus. Number two, political reasons. And then you'll have to explain it in one line. Lack of consensus should be your headline. Although the Hindu code laws were codified in the 1950s, but the personal laws related to minorities were left untouched because the country witnessed partition along the religious grounds. It was thought that through consensus over a period of time, we will enact a uniform civil code for all the citizens. That consensus is still lacking. So, lack of political consent, lack of consensus is the reason number one. Political reason is number two. Although there has been codification of personal laws in Muslim majority countries as well, such as Pakistan, such as Egypt, such as Bangladesh, but the codification of the Muslim personal laws could not happen in India because of political reasons. For example, Shah Bano case. And the examiner would know what you are referring to. I've said this is a controversial thing. Can we mention it in the answer? You have to mention because this is a political question. And the reason is politics, why Uniform Civil Code could not be implemented. Fine. Third, because of the clash of fundamental rights with directive principles of state policy. According to series of Supreme Court judgments, fundamental rights are superior and directive principles are inferior. Barring Article 39B and 39C, no other directive principle has superiority over fundamental rights. Article 29, every section of the citizens will have the fundamental right to preserve their culture. Article 25, every section of the people in India, they have the fundamental right to profess, practice, and propagate their religion. So there are some principles, some practices which will be redundant if Uniform Civil Code is implemented. Thereby will be a clash of fundamental rights with DPSPs. Now you gave the examples of any body. So if there is a committee, if there is a body, if there is a report, mention that, that will add value to your answer. Mention the report of the Law Commission, that it is not desirable to have a uniform civil code right now. Conclusion, through political awareness, by strengthening the Special Marriage Act, we can go a long way in ensuring a common, equitable law for all the sections of our citizens. So you can say, even without implementing Uniform Civil Code, by strengthening, creating more awareness about the Special Marriage Act, we can ensure the impact of Uniform Civil Code. Although Uniform Civil Code is not passed, but the impact of Uniform Civil Code will be there by strengthening the Special Marriage Act. That should be your answer. Clear? Principles of state policy. You need to use it multiple times in your answer. First time you mention directive principles of state policy in bracket DPSP. Then you can write only DPSP. But first you have to say what is DPSP. Clear? Parliament's power to amend the constitution is a limited power and it cannot be enlarged into absolute power. In light of the statement, explain whether Parliament under Article 368 of the Constitution can destroy the basic structure of the Constitution by expanding its amending power. Parliament in an Parliament in a written constitution such as India has limitations. Doctrine of limitation or doctrine of limited government. Although the plain reading of the original constitution did not impose any restriction on the powers of the parliament in amending the constitution, but the judicial innovation of the doctrine of basic structure, as propounded by the Supreme Court in Keshavananda Bharati versus State of Kerala, the Supreme Court has said that Parliament does not have unlimited power in amending the Constitution. It can amend any provision of the Constitution subject to basic structure. And what constitutes basic structure is a judicial innovation. This cannot be enhanced into an absolute power by the Parliament. Although the Parliament did manage to amend the Constitution by enacting 24th Amendment, 25th Amendment, by ensuring that Parliament has the unlimited power in amending the Constitution. But because of the various judicial pronouncements, Golaknath, Keshavananda Bharati, Minerva Mills case, the Supreme Court has imposed limitation on the powers of the Parliament in amending the Constitution. It is not an absolute power. Cite various judgments. So, court is given. Parliament's power to amend the Constitution is a limited power. It cannot be enlarged into an absolute power. Now you will have to explain the statement. So basically, you'll have to explain Keshavananda Bharati case and cite various other cases where the court has imposed limitations on the amending powers by the Parliament. The Attorney General is the chief legal advisor and lawyer of the Government of India. According to Article 76 of the Constitution, the Attorney General performs the following roles, which makes the Attorney General the chief legal advisor and lawyer of the Government of India. Number one, to advise and assist the central government in all cases where the central government is a party. Number two, to present the viewpoint of the central government on any presidential reference made under Article 143. Third, to advise the president, to advise the central government on all legal matters as may be assigned to him. For example, in imposing president's rule. For example, in making laws. The Attorney General is the chief lawyer. And you'll have to write in 15 marks, which means in 150 words. Clear? Compare and contrast the British and Indian approaches to parliamentary sovereignty. 10 marks, 100 words. Compare and contrast. Britain is a constitutional monarchy. It has an unwritten constitution, and in an unwritten constitution, Parliament is supreme. Parliament has the absolute power in making all laws. In the words of D. Lolme, Parliament of Britain can do anything except convert a man into a woman and a woman into a man. In contrast, India follows a written constitution where constitution is supreme and Parliament has a limited power in amending the constitution. All the laws passed by the Parliament of India are subject to judicial review. While as in Britain, British Parliament can pass any law, judiciary has a limited role in British parliamentary system. In India, there is a difference between a constitutional law and an ordinary law. In Britain, there is no difference between a constitutional law and a parliamentary law. In India, there is a difference between a constitutional law and a parliamentary law. What is this parliamentary sovereignty in India and Britain that you will have to compare and contrast? By looking at these first four questions, roughly 7.5 minutes. 15-mark question, then you'll have to write answer in less than 250 words. Answer can be in 200 words. It can be in 150 words, but it cannot cross 250. Of India are freely available to the Indian citizens But these rights are not absolute. Mention the articles. If you can remember, that will add weight to your answers. Article 19(1)(d) and 19(1)(e) of the Constitution. Try to implement the lofty goals of fraternity that are mentioned in the preamble of the Indian Constitution. These rights are exclusively available to the citizens so that through right of movement and right to reside anywhere within the territory of India, we can break the imaginary walls of language, religion, caste, tribal identity, and make India a united one, a sense of fraternity, a common brotherhood. But these fundamental rights are not absolute because restrictions can be imposed on your freedom of residence, freedom to travel, on the following grounds. Number one, in the interest of the general public. For example, during the COVID 19 pandemic, restrictions were imposed on the freedom of movement. Freedom of movement, for example, leprosy patients. You can also talk about that those who are habitual offenders, their right of movement can be restricted. And we have discussed a case as well when we discussed these two fundamental rights. And these fundamental rights can also be restricted in the interest of the scheduled tribes. For example, Jarawas, Sentinelese, give their recent example. Problem solved. In 150 minutes, you will be able to answer. Vice President of India as the chairman of Rajya Sabha. And this is the topic that we will discuss more in Union Legislature. Because we will compare it with the Speaker of the Lok Sabha. Do you think that Constitution of India does not accept principle of strict separation of powers? Rather, it is based on the principle of checks and balances. Explain. The theory of separation of powers, as attributed to French philosopher Montesquieu, talks about separation of powers amongst the three organs of the state, where one organ cannot influence the other organ, one organ cannot take away or take over the role performed by the other organ, which means all the three organs will perform their task based on their own strengths under their own domain, and one organ will not influence the other organ. But to implement this theory of separation of powers, it was felt that we need one organ to be kept under check by the other organ. And that is how the doctrine of checks and balances emerged. And the Constitution of India provides for checks and balances under the following circumstances. Number one, Union Executive vis-a-vis questions, debates, budget, judiciary or members of the judiciary appointed by executive, removed by executive on the basis of resolution passed by legislature. Legislature also kept under check. If the laws passed by the legislature can be challenged in the court of law on the grounds of judicial review. Judicial review is also part of the basic structure of the Constitution. You can also write in your conclusion that although the Constitution of India recognizes separation of powers between executive and judiciary and not between executive and the legislature under Article 50 of the Constitution, the doctrine of checks and balances have been weakened over the recent past when it comes to judiciary. Dr. Ambedkar thought through appointment and removal process, the executive and legislature can keep a check on the judiciary. But because of the judicial verdicts of 1993 and 1998, with the emergence of collegium system of judicial appointments, India is the only country where judges are appointed by themselves. And such is the difficult process of the removal of the judges that till date no judge of the Supreme Court has been or High Court has been removed. In light of above reasons, we can say that although for executive and legislature there are strict checks and balances in place, but when it comes to judiciary, the checks and balances have been weakened in the recent past. The enactment of NJAC, National Judicial Appointments Commission, was a step in the right direction to ensure checks and balances under the Indian constitutional scheme. Full stop, problem solved, paper is done. Versus right of choice, explained with the help of various Supreme Court verdicts. Is it appropriate to reference the right to marry in this context? Right of choice and right to life, the context becomes the abortion laws in India. There was a lady who was 26 weeks pregnant. She wanted to terminate her pregnancy, but then came the question of fetal viability. The AIMS doctors, they sent a letter, a mail to the Supreme Court saying, before performing abortion, should we stop the heartbeat of this fetus because the fetus is viable? Viable in the sense, even if we take this fetus out of the mother's womb, the fetus will still survive in laboratory conditions. So when the fetus is viable, that means can survive even outside the womb of the mother, this fetus will have the right to life as well. So how do we reconcile right to life and right of choice of this woman to decide to terminate her pregnancy? This it was in this context that this question was framed. Can we start writing with any court? A court which is relevant, not any court. Yes, judicial independence does not mean that you become a dictatorial institution where there are no checks and balances on you. Independence of judiciary means whenever the judiciary has to give verdict, it should not be biased. It should give verdict based on facts, based on evidence. But that doesn't mean you become such a powerful institution that there are no checks and balances on you. Let's precedent union legislature. According to Article 79, the Indian Parliament consists of President and the two houses, which are known as House of People, Lok Sabha, Council of States, Rajya Sabha. So if the question comes, Indian Parliament consists of President, Lok Sabha, and Rajya Sabha, which means President is an integral part of both executive as well as the legislature. We have discussed the office of president, but we will revisit the office of president as I promised you in union legislature. But first up, what are the functions of the parliament? We say parliament is nation in miniature. Represents the diversity of India. India is a diverse land. The diversity is not only with respect to religion, it's also with respect to language, different regions, different cultures, different castes, different tribal groups. And Indian parliament represents all of them. So there are people in the parliament belonging to different religions, different castes, different tribes, different languages, different regions. So we say it's like nation in miniature. It's like the sample of India. It represents the entire nation. It has a parliament. It has a function of ordinary lawmaking. There is something known as Schedule 7 of the Constitution, which talks about distribution of legislative subjects. Union Parliament, these are the powers which are available to you. State legislatures, these are the powers available with you. These are the subjects on which you can make laws. And concurrent list, where both Parliament as well as state legislature has the power to make laws. All these laws become ordinary laws. And this is the ordinary law making power of the Parliament, that Parliament has the power to make a law on any item mentioned in the Union list, on any item mentioned in the concurrent list. For example, in Union list, we have citizenship. Who has the power to make a law on citizenship? Parliament. In concurrent list, we have the subjects such as marriage and divorce. Special Marriage Act. Who has the power to make such a law? Parliament. Similarly, we have criminal procedure, civil procedure. If tomorrow there are 3 bills which are to be presented to the Parliament, one replacing the Evidence Act, the other replacing the criminal procedure, the other replacing the civil procedure, all these are the laws to be passed by the Parliament, because that is the power of the Parliament to make ordinary laws. But Parliament has the power not only of making ordinary laws, it has a constituent power as well. What is the constituent power of the Parliament? It has the power to amend the Constitution, subject to basic structure. Apart from making ordinary laws, Parliament also has the constituent power. That means it acts like a constituent assembly to amend the provisions of the Constitution without violating the basic structure. It also controls the executive, also supplies the executive. Who all are part of the Council of Ministers? If you are a member of Lok Sabha or Rajya Sabha, you are eligible to be appointed as a minister. Even if you are neither a member of Lok Sabha nor Rajya Sabha, you can still be appointed as a minister, but within 6 months, you have to get yourself elected to either of the 2 houses of the Parliament. That means another job of the Parliament is that it supplies us with the executive. Those who are part of the Parliament, some of them are made ministers as well. That means they become part of the executive. And then the Parliament controls the executive. How? Through questions, through resolutions, through motions, through debates. It is these various tools which are employed by the legislature, by the Parliament, through which it keeps a check, controls the executive. It is the custodian of public purse. We will discuss in Union Legislature, there is a fund known as Consolidated Fund of India, where almost the entire money is deposited. All the investments raised, all the taxes that are imposed, all the FDI that comes into, all that is deposited into this fund known as Consolidated Fund of India. All the loans that are generated, that are taken by the central government, gets deposited in the Consolidated Fund of India. But the ministers, the executive, cannot spend even a single penny from Consolidated Fund of India without the approval of the Parliament. So without parliamentary approval, government cannot spend even a single penny from this Consolidated Fund of India. And Consolidated Fund of India then becomes the custody of the Parliament. Parliament is the custodian of this public purse, public money. Parliament is also the source of authentic information. What is the source of authentic information? Parliament. How? Every 9 o'clock in the evening, one preacher in chief, Mr. Goswami, says the nation wants to know And then there is allegation against the media that the media is not reporting facts. The media is only reporting their own biases. But if you want to know authentic information on a particular matter, for that we have to go to the parliament. Parliamentarians will ask questions to the executive. Executive will have to give the correct answer. How many individuals are without jobs? I need the answer from the particular minister. He can't lie inside the parliament. He has to give the authentic information. That means parliament has another power, another function, another role to play. It supplies the people of India with authentic information. And that is why we say parliament performs multiple roles and functions. And some of the broad functions that parliament performs are these. It reflects and represents the diversity of India. It has the ordinary lawmaking power. It has the amending power as well. It is the custodian of public revenue. It supplies us with the executive. It controls the executive. And it is also the authentic source of information. All these are major functions that are performed by the parliament. An Indian parliament consists of president, Rajya Sabha, and Lok Sabha. Let's first look at Rajya Sabha. Then once Rajya Sabha is done, then we will discuss Lok Sabha, and then we will club the two together. Then we will discuss parliament as an institution together. First, we will look at what is the composition of Rajya Sabha. The maximum strength of Rajya Sabha is 250. So what is the maximum strength of Rajya Sabha? 250. What is the existing strength? It is 245. Maximum strength is 250. Existing strength is 245, which means tomorrow, unless and until we increase the number of seats, this is going to remain the position. 255 is going to be our existing strength. Out of this, some members are elected, some members are nominated. How many elected members do we have? 233. How many nominated members do we have? 12. Some members will be elected by states. Some members will be elected by union territories. How? We will discuss. But who are these 12 nominated MPs of Rajya Sabha? These are nominated by the president from the fields of art, literature, science, social service. Listen to me carefully. Is it binding on the president to nominate these 12 MPs to Rajya Sabha? Yes. But it is not the personal discretion of the president to nominate any of these individuals to Rajya Sabha. It's basically on the advice of the Prime Minister, because president does not have the real power. The real power is with the Prime Minister and his Council of Ministers. So basically, it is on the advice of the Prime Minister that president is mandated, it is binding on the president to nominate 12 MPs to Rajya Sabha. And who are these 12 MPs to Rajya Sabha? Those individuals who have performed well, who have contributed brilliantly in the field of art, literature, science, social service. And 12 members are to be nominated by the president. But the questions are two. Number one, why nominated? And number two, only on the grounds mentioned? to make laws? Parliament. How are the members added to the parliament? Through elections. But in elections, if I have to participate in the election, I have to spend a lot of money to get myself elected. I have to unfortunately polarize people as well into different religions so that people of different religions vote for me. I have to polarize people on different caste levels as well, on the grounds of language as well. I have to criticize each other as well. I have to go through the dust of election campaigning to convince people to vote for me. But what if I'm not like that? What if I can't polarize people in the name of religion, race, caste, language, residence? What if I cannot enter into the dust of this politics, campaign from one part to another part and ask people to vote for me? But nevertheless, I can be a good contributor to lawmaking process because I have done spectacularly well in the field of art, literature, science, social service. And my expertise in these areas will help Parliament in framing a better law. So Parliament provided, Constitution provided that in Rajya Sabha we will have two different categories of members. Some who will be elected and some who will be nominated. These people, they are well versed. They have done spectacularly well in some fields such as art, literature, science, social service, but they cannot enter the election arena, enter the dust of the elections, and campaign for themselves to get themselves elected. Nevertheless, they can be good contributing factors. They can be good contributors to the lawmaking exercise. Constitution said we will provide them an unelected route. They don't have to get elected to Rajya Sabha. They will be unelected and nominated to Rajya Sabha so that these talented individuals can also be part of lawmaking exercise. So that talented individuals can participate in lawmaking. Question number 2. Is it that President will have to nominate 12 MPs to Rajya Sabha only from the fields of art, literature, science, social service, from no other field? If from no other field, then how Sachin Tendulkar was nominated? He clearly does not fall in the category of art, literature, science, or social service. He comes under the sports category. For that, we have an explanation given by constitutional expert Soli Sorabji, who unfortunately is not alive now. Soli Sorabji was the Attorney General for India, a constitutional expert. He says these grounds mentioned in the Constitution, it is only for illustration. It is only an illustrative list. It is not an exhaustive list. What is the difference? When Constitution says that 12 MPs to Rajya Sabha can be nominated by the President, the Constitution also provides for an illustration, also gives an example that these 12 nominated members can be from fields such as art, literature, science, social service. So only example is given, illustration is given that from such fields 12 MPs can be nominated. But that doesn't mean it's an exhaustive list. That doesn't mean only from these areas the President can nominate 12 MPs. President can nominate from other segments as well, from other areas as well, such as sports, such as any other criteria. That is how Sachin Tendulkar came to be nominated. Which means when we are discussing Rajya Sabha, first we have to discuss the composition. We say the maximum strength provided by the Constitution is 250, but our existing strength is 245. Out of which 33 are to be elected, 12 are to be nominated. Who are these 12 nominated MPs? Those who have performed well in the field of art, literature, science, social service. It is mandatory for the President to nominate these 12 MPs on the advice of the Prime Minister. And the nominated route is provided so that we can have talented individuals who may not want to contest elections, who may not want to enter the well of election campaigning, but are still important for lawmaking business, for lawmaking exercise. Rajya Sabha provides opportunity to such talented individuals to also become part of lawmaking exercise. And it is not that the president will have to nominate MPs only from these fields: art, literature, science, social service. Constitution only provides for an illustration that president can nominate 12 MPs from fields such as art, literature, science, social service. That doesn't mean president has to restrict itself only to this list. President can nominate anybody who has performed spectacularly well in any field in India, so that you can be part of lawmaking exercise and you can become the member of Rajya Sabha. Is nominating Ranjan Gogoi, who was the Chief Justice of India, to Rajya Sabha, is it violation of the separation of powers? No. Why? Because if Justice Ranjan Gogoi, as the Chief Justice of India, was nominated to Rajya Sabha, it would have been violation of separation of powers. Because a member of the judiciary cannot become part of the legislature as well. But now Justice Ranjan Gogoi's term is over. That means he is no longer the judge. He is no longer part of the judiciary. He is like a common man, but who has performed well in some areas. His contribution is to the judiciary. He has performed well in some areas. Now he is an ordinary citizen of India, and as an ordinary citizen of India, he was nominated to Rajya Sabha. So it is not a violation of separation of powers. But the remaining 233 are to be elected by states or union territories. How? 225 are elected by states, 8 are elected by union territories. But only 3 union territories participate. 1, Delhi. 2nd, Puducherry. 3rd, Jammu and Kashmir. 3 MPs from Delhi, 1 from Puducherry, 4 from Jammu and Kashmir. Which basically gives you a sense that MPs to Rajya Sabha are elected by members of legislative assemblies. Members of legislative assemblies vote to elect MPs to Rajya Sabha. Where do we find legislative assemblies? In states. Where do we find legislative assemblies? In union territories. And there are only 3 union territories which will have a legislative assembly or which has a legislative assembly. One is Delhi, the other is Puducherry, the third is Jammu and Kashmir. How the election takes place? For that, we need to understand Schedule 4 of the Constitution. What is Schedule 4? Representation of states in Rajya Sabha. For example, from UP, we will have 31 MPs in Rajya Sabha. Where is it mentioned? Schedule 4. From Telangana, we will have 7 MPs in Rajya Sabha, mentioned in Schedule 4. From Jammu and Kashmir, we will have 4 MPs in Rajya Sabha, mentioned in Schedule 4. From Delhi, we will have 3 MPs in Rajya Sabha. One of them would be Raghav Chadha, who is no longer an Aam Aadmi. The other would be Harbhajan Singh. The other would be Sanjay Singh. These 3 MPs to Rajya Sabha will be from Delhi. Although Raghav Chadha and Harbhajan Singh, they were elected from Punjab, but they belong to the Aam Aadmi party. So states, what is going to be the representation of states in Rajya Sabha? That is mentioned in Schedule 4 of the Constitution. But how does the election take place? Election takes place through a system of proportional representation system, by means of single transferable vote, but this time through open ballot. How? Let me give you an example. Let's suppose There is a state X. From the state, we have to fill 3 vacancies in the Rajya Sabha. Who will vote to elect these MPs? The Legislative Assembly of that state. Let's say total number of MLAs divided by vacancies +1 +1. This is the total number of votes required to get elected to Rajya Sabha. How? Let's say, for example, for this state X, we have 3 vacancies, which means we have to send 3 MPs to Rajya Sabha from this state X. Let's assume the total number of MLAs in this state are 300. Total vacancy is 3 +1 +1, which means 300 divided by 4 means 75 +1 means 76. Whoever gets 76 votes will be elected to Rajya Sabha. How does this election take place now? All the MLAs who are part of the state X, they will have to vote. They will vote to elect 3 MPs to Rajya Sabha. Let's suppose out of this 300, we have, let's say, 150 belonging to BJP, 80 belonging to Indian National Congress, which means 230, and now 70 is from Aam Aadmi Party. Assume proportional representation system. That means in proportion to your strength, those many votes you will have. That means even before the election takes place, we know for sure that out of these 3 vacancies, one will be from BJP, the other will be from Congress. Because how many votes do you need? 76. So all these 80 MPs of Congress, 76 of them, they will give preference to A. Out of these 150 MPs from BJP, 76 of them will vote for B. They have another candidate C, and the remaining will vote for this candidate C. What is the remaining number now? 74. And Aam Aadmi Party, now they have to decide whether they want to contest elections or not, or whether they want to support someone else or not. Aam Aadmi Party and Indian National Congress, they will come into picture. They will start an alliance. Indian National Congress will say, we have 4 extra votes. Because 76 of our MLAs, they voted for A, we have 4 extra votes. Please ask 70 of your MLAs to also vote for our candidate number 2. So that total we can have 74 votes. In this case, what will happen? 74 votes will be given to this candidate, the second candidate of the Indian National Congress. What will happen to the second candidate belonging to the BJP? The second candidate also has 74 votes. But now in this case, now we will have to look at the second preference of the votes. And those who voted for C as their first preference, what was their second preference? Those who voted for candidate Y of the Congress, what was their second preference? Now those votes will be transferred. And whoever gets 76 votes, that person is the winner. That means even without voting, you will still get to know from which political party how many candidates would get elected, because we follow the system of proportional representation system. For example, in Delhi, we have three vacancies. Total MLAs are 70. Three vacancies plus 1, which means 70 divided by 4 plus 1. 70 divided by 4, what is the value? 18, close to 18. So whoever gets 19 votes will be elected from Delhi. Now in Delhi Legislative Assembly, Aam Aadmi Party has 62 MLAs. So all the three MPs from Delhi in Rajya Sabha will be from Aam Aadmi Party, because Aam Aadmi Party will tell its MLAs that this is our candidate A, 19 MLAs should vote for him. This is our candidate B, 19 MLAs should vote for him. This is our candidate C, 19 MLAs should vote for this individual. That means they will have all the three MPs in the Rajya Sabha from their own political party, because we follow proportional representation system. But this time it is through open ballot. That means when these Aam Aadmi Party MLAs vote, they have to show the representative of the Aam Aadmi Party that, look, I am voting for our candidate. If I vote for some other candidate, I will be disqualified. That is what we call how election takes place to Rajya Sabha. It is if we have 233 MPs to Rajya Sabha to be elected. Election takes place in the legislative assemblies. That means those states which have a legislative assembly and those union territories with legislative assembly, only their MPs will be there in Rajya Sabha. And that is why we call Rajya Sabha Council of States. It represents states with legislative assemblies in parliament. Why Rajya Sabha is called Council of States? Because it represents states in the parliament. States with legislative assembly and those union territories with legislative assembly, they participate to elect MPs to Rajya Sabha. And how MPs are elected to Rajya Sabha? Through proportional representation system, by means of single transferable vote, through open ballot. Open ballot in the sense you have to show it to your representative. I am voting for my candidate. I am not voting for someone else. I am not cross voting. And for that, the formula is total number of MLAs divided by vacancies plus 1 plus 1. This is the number of votes required. And whoever gets these many votes will be elected to Rajya Sabha. Clear? What are the qualifications? For someone in order to contest Rajya Sabha election? First, you have to be the citizen of India. Second, must have completed 30 years of age. Should be a registered voter in any parliamentary constituency in India. Should also not hold. First, you have to be the citizen of India. You must have completed 30 years of age. Your name should be mentioned in the voter list in any parliamentary constituency of this country. That means even if your name is mentioned in the voter list of Telangana, you can get elected to Rajya Sabha from Andhra Pradesh. You can get elected to Rajya Sabha from Assam. You can get elected to Rajya Sabha from Chhattisgarh. And also, you should not be holding any office of profit. If time permits, we will discuss office of profit today. If not, then on Wednesday. Then we say Rajya Sabha has some special powers. What are the special powers of Rajya Sabha? Number 1, Article 67, Clause B. Something that we discussed when we discussed the office of Vice President. Vice President of India can be removed from his office. On what grounds? These grounds are not mentioned in the Constitution. But Vice President of India can be removed from his office on the basis of resolution passed by Rajya Sabha by effective majority. And then this resolution should be accepted by Lok Sabha by simple majority. But where can we introduce this resolution? Who can initiate the process of the removal of the Vice President? Only Rajya Sabha. That is why we say it is the special power of the Rajya Sabha. Because this resolution calling for the removal of the Vice President cannot be initiated in Lok Sabha, it can be initiated only in Rajya Sabha. That is the special power of Rajya Sabha. Another special power, Article 249. There is something known as Schedule 7, where the powers are distributed into union list, state list, concurrent list. Who has the power to make a law on union list? Parliament. Who has the power to make a law on concurrent list? Both Parliament as well as the state legislature. But who has the power to make a law on state list? State legislature. But there is a special power given to Rajya Sabha. Dear Rajya Sabha, if Rajya Sabha passes a resolution by 2/3 members present and voting, then Parliament can legislate on state list in national interest. A special power is given to Rajya Sabha. We say Rajya Sabha represents states. Rajya Sabha protects the interest of the states. But what if it is in the interest of nation for Parliament to pass a law on state list? For that, Rajya Sabha has to pass a resolution. Under Article 249, if Rajya Sabha passes a resolution by 2/3 of the members present and voting, then Parliament becomes empowered. That dear Parliament, you can make a law on state list. The validity of this law will be 1 year. Let's say in the late 1980s, when the terrorism erupted in Jammu and Kashmir, law and order was a state subject. Law and order is under the state list. That means under the state legislature has the power to make a law on law and order. But what if it is in national interest for Parliament to make a law on law and order? For that, you have to take the permission of the Rajya Sabha. Rajya Sabha, if it approves by 2/3 members present and voting that yes, Parliament should make a law on state list because we are there to protect the interests of the states, then Parliament can make a law on state list, but the validity will be for 1 year. If Rajya Sabha passes a resolution by 2/3 majority again, this law can continue for another 1 year. That means every year you have to take the approval of Rajya Sabha. Because Parliament in this case is making a law on law and order, which is a state list. How can Parliament legislate on state list? If Rajya Sabha, which is protector of the state interest, allows, approves, then Parliament can make a law. That is the special power of Rajya Sabha. And then we have a third special power of Rajya Sabha, which is Article 312. How many All India services do we have? One is IAS, one is IPS, one is Indian Forest Service. What is an All India service? Basically, these members, these officers are recruited by the center based on the examination conducted by UPSC. They're trained by the center. They're accountable to center. President appoints you, president can remove you tomorrow. President appoints you, president can dismiss you tomorrow. But where do you work? You work in the states. That is why there have been, we will discuss in center-state relations, there have been some states which have previously passed resolution that we don't need All India service officers. because we want our own officers to work with us. We want our state service officers to work with us, because we don't have control over all India service officers. They're appointed by the center, they're trained by the center, they're accountable to center. What if a new all India service is to be created? Who can create a new all India service? Who has this power to make or create a new all India service? This power is with the parliament. But parliament can create a new all India service only if Rajya Sabha passes a resolution by 2/3 members present and voting. If Rajya Sabha passes a resolution by 2/3 of the members present and voting under Article 312 of the Constitution, then only Parliament can create a new All India service. Otherwise, Parliament cannot. Because these All India service officers, they basically work in the states, but they are accountable to the center. They're recruited by the center. They're trained by the center. That is why we say Rajya Sabha is the Council of States. It protects the interest of the states. If there is no need for Parliament to make a law on state list, because it will violate the powers of the state, if there is no need to have a new All India service, because it will encroach upon the powers of the state, then Rajya Sabha will not allow. That is why we say Rajya Sabha is the protector of the interests of the states. So Indian Parliament consists of President, Rajya Sabha, Lok Sabha. President we have discussed, although briefly. Now we are discussing Rajya Sabha. Then we will discuss Lok Sabha. Then we will discuss all the three together. We say Rajya Sabha has 250 as the maximum strength. But existing strength is 245. Out of 245, 233 are to be elected, 12 are to be nominated, 12 nominated by the president. It's mandatory for the president, on the advice of the Prime Minister, to nominate 12 MPs to Rajya Sabha from the fields of art, literature, science, social service. But this is not an exhaustive list. That means you can go beyond this list and nominate MPs to Rajya Sabha from any other field. But 233 are to be elected by legislative assemblies. That means MLAs of states and MLAs of union territories, they vote to elect MPs to Rajya Sabha. Clear? But who is qualified to contest this Rajya Sabha election? If you are a citizen of India, if you have completed 30 years of age, if you are a registered voter in any parliamentary constituency, and if you are not holding any office of profit. And once you are elected, then we say Rajya Sabha has got three special powers. What are these three special powers? The resolution calling for the removal of Vice President can be initiated only in Rajya Sabha. Although later it requires approval by Lok Sabha as well, but can be initiated only in Rajya Sabha. Special power is under Article 249. Parliament can make a law on state list and national interest only if Rajya Sabha accepts it. Only if Rajya Sabha passes a resolution by 2/3 majority. Can Parliament create a new All India service? Yes, but only if Rajya Sabha passes a resolution by 2/3 of the members present and voting. So Article 249, Article 312, Article 67 Clause B, these are the special exclusive powers available with Rajya Sabha. These powers are not available with Lok Sabha. There is reservation for SCs and STs, but in Rajya Sabha there is no reservation. Voting takes place through open ballot. We say Rajya Sabha is the permanent house of parliament. When we say permanent house, that means not subject to dissolution. Lok Sabha can be dissolved, and Lok Sabha gets dissolved every 5 years. But Rajya Sabha cannot get dissolved. Rajya Sabha is the permanent house of Indian Parliament. It remains there forever and ever and ever. And how to ensure this permanent nature of Rajya Sabha? 1/3 members retire every 2 years. The term of an MP of Rajya Sabha is 6 years. Mentioned in Representation of the People Act. This is something which is not mentioned in the Constitution. Constitution does not say that the term of the Rajya Sabha MP is 6 years. It is mentioned in the Representation of the People Act. But the term of a Rajya Sabha MP is 6 years, and 1/3 members retire every 2 years. Aren't both these things contradictory to each other? No. Then let's discuss. Let's assume for a while that there are 100 MPs in the Rajya Sabha. Let's assume there are 100 MPs in Rajya Sabha. What is the term of an MP of Rajya Sabha? 6 years. That means if these 100 MPs were elected on 1st January 2020, then on 31st December 2025, their term is over. Because the term is 6 years. Which ultimately means on 31st December 2026, Rajya Sabha would be vacant. There will be nobody in Rajya Sabha. Rajya Sabha would be dissolved. Then fresh election is to be conducted to elect these 100 MPs, just like we do it in Lok Sabha. So in Lok Sabha, if there are 543 MPs who get elected by the people, once their 5-year term is over, Lok Sabha gets dissolved. Then we have a new Lok Sabha which has newly elected MPs. But Rajya Sabha is the permanent house of Indian Parliament. Rajya Sabha should never be dissolved. Rajya Sabha is not subject to dissolution. It is the permanent house of Indian Parliament. How to ensure the permanent nature of Rajya Sabha? For that, in 1951, when the Rajya Sabha was set up for the first time, we decided to do something. And what did we say? Out of these 100 MPs, after 2 years, 33 MPs will retire. They will resign. Why? 100 is the strength of Rajya Sabha. All these 100 people will have 6-year term. But how do we ensure permanent house, permanent nature of Indian Parliament? We select 33 MPs. We tell them resign after 2 years. Resign after 2 years. But how do we select them? Through draw of lots. We take 100 MPs, their chits, and we pick 33 chits. These names, 33 names which appear, we tell them you resign. Resign after 2 years. So that once you resign after 2 years, this is 1, 2, 3, 4, 5, 6. 6 year is the term of the Rajya Sabha MP. If these 33 MPs are made to resign after 2 years through draw of lots, we will tell them you contest election again. Contest election again. Now your term will be for 6 years. But so that these 33 seats, these 1/3 seats, their term is now 6 years. That means their election would be at a different date as compared to others. 4 years are over. We ask these 33 MPs, you also retire, resign. So that once these 33 seats are to be filled, now your term is 6 years. And these 33 MPs, in any case, they remain there for 6 full years. Now, once their term is over, there will be election. So this is confusing. No, this is not. This is very easy. Easy in the sense, if there are 100 MPs in Rajya Sabha, we have to ensure the permanent nature of Rajya Sabha so that it is never empty, it's never vacant. It is the permanent house of Indian Parliament. What do? All these 100 MPs, they will come from some states. They will come from some union territories with legislative assemblies. We asked these 33 MPs, let's say in 1952, we asked these 33 MPs to resign. You will contest elections again, but once you are elected, in 1952, we have got these 100 MPs. 2 years later, in 1954, we asked 33 MPs to retire, which means election will take place to fill these 33 vacancies. And now their term is till 1960, 6 years. In 1956, we asked 33 MPs again to retire. You can contest election again. But once you contest election again, now your term is till 1962. And those who got elected in 1952, their term was till 1958. That means these 33 MPs also, their term is till 1958. That means now when this election will be conducted again, their term will be till 1964. Which means there are 1/3 seats right now where election takes place every 2 years. We started this process when we asked in 1954, 1/3 members, you resign after 2 years, so that we can have fresh election for your seats, your 1/3 seats, and then their term will be for 6 years. Then after 4 years, we asked 33 MPs to retire again, 1/3 MPs to retire again. Once their term got over, once they resigned, fresh election was conducted. That means now elections will always take place at different times. 1/3 for this year, 1/3 for 2 years later, 1/3 for 2 years later. That means at every point in time, we will have MPs in Rajya Sabha. Rajya Sabha will never be dissolved. It will remain the permanent house of Indian Parliament. Now, we don't need to ask them to resign after 2 years. Because all those seats, their term is 6 years. All the seats, their term is 6 years. But in the first 2 years, we asked 1/3 MPs to retire. Once they resigned, now we called fresh election. Now their term is 6 years. After 4 years, we asked 1/3 MPs to resign. Once they resigned, fresh election was conducted. Now we got election to elect these 1/3 MPs. That means now all these 245 seats or all these 233 seats for which election takes place, 1/3 their election takes place today in 2023. For another 1/3, the election takes place in 2025. For another 1/3, the election takes place in 2027. Which means at any given instant, Rajya Sabha is full of members. Rajya Sabha has MPs. Rajya Sabha cannot be dissolved. It is not subject to dissolution. That is how we ensure the permanent nature of Indian Parliament. Sir, but you told that J&K yet don't have a legislative assembly while discussing presidential election, but now you included J&K in Rajya Sabha elections. I did not. The government has. In 2019, on 6th of August 2019, when Jammu and Kashmir reorganization bill was passed, at that time there were 4 MPs from Jammu and Kashmir in Rajya Sabha. 3 of these MPs were from Kashmir, 1 from Ladakh. But now Jammu and Kashmir is a union territory. Ladakh is a union territory without legislative assembly. The question was, how will these 4 people be accommodated? The government said, all these 4 people we will treat as if they are the members of the union territory of Jammu and Kashmir and Rajya Sabha. As if election has already happened and they have been elected to Rajya Sabha. Because who elected them? Legislative Assembly of Jammu and Kashmir. When it was a state. So when they were elected to Rajya Sabha from the Jammu and Kashmir Legislative Assembly, now we say that Jammu and Kashmir Legislative Assembly is not of a state, it is of a union territory. So we can say these four were elected by Jammu and Kashmir Union Territory Legislative Assembly. And today, there is no representative from Jammu and Kashmir in Rajya Sabha. Because all these four MPs who were part of Rajya Sabha from Jammu and Kashmir, their term was for 6 years. So that term got over because since 2018 we have not had elections in Jammu and Kashmir. So now we have no representative currently in Rajya Sabha from Jammu and Kashmir. Once Jammu and Kashmir elections will take place, Legislative Assembly MLAs will be elected, then they will elect four MPs to Rajya Sabha from Jammu and Kashmir, but not from Ladakh because Ladakh is a union territory without a Legislative Assembly. There won't be a representative of Ladakh in Rajya Sabha. 2024 there is election for 65 seats, so election is continuous. Let's suppose one third MPs retire every 2 years. Clear? Now let's say one third number is 70. For example, out of the 70 MPs, once elections are held, I will remain in office for 6 years. But what if 10 of them they are disqualified? What if 5 of them die? What if 5 of them resign? We have to have elections for those vacancies as well. That is why 10 seats were election took place. It was a by-election, basically to fill the vacancy because there was a vacancy because of death, resignation, or disqualification. And the remaining 65, those are those seats which normally get vacated every 2 years. Nominated members are also nominated for 6 years. So Rajya Sabha seat, if it gets vacant, then the new one holds the office for 6 years or the remainder of the term. Remainder of the term. Let's say, for example, we have Mr. Rahul Gandhi as the member of Lok Sabha from Wayanad constituency. What if the term is for 5 years? What if after 2 years Rahul Gandhi resigns or is disqualified? Then fresh election will happen in Wayanad constituency. Now, if I am now elected to Lok Sabha from Wayanad, will I remain in office for the entire 5 years or for the remainder of the term, which is 3 years? I will remain in office for the remainder of the term, which is 3 years. Same goes with Rajya Sabha MP as well. If this Rajya Sabha MP had a term of 6 years, after 2 years, he was disqualified, or he resigned, or he died. Now, when fresh election will be conducted for this seat, you will remain in office only for the remainder, which is for 4 years, not for the entire 6 years. It's 6 years tenure, he has to contest 3 times. We drew this lots only 2 times in the past. 1954, so that we can have one third seats whose term would be different for others. Then in 1956, so that we can have one third seats whose term would be different from others. After that, those one third seats which we made to resign in 1954, now for them the term is 6 years. But from 1954 till 1960, then 1960 to 66, 66 to 72, 72 to 78, 78 to 84, 84 to 90, 6 year term continues. But for the remaining seats, one third seats, their term starts 1954 or their term starts 1956. So from 1956 to 62, 62 to 68, 68 to 74, 74 to 80, now their term is 6 years. And those who completed their term in 1958, all those seats will now have 6 year term. 58 to 64, 64 to 70, 70 to 76, so on and so forth. Sir, is there a person who is continuously elected to Rajya Sabha? Dr. Manmohan Singh, continuously elected to Rajya Sabha. It allows talented individuals to participate in law-making exercise. Number two, we say it represents the interests of state in parliament, and that is why we call it a federal chamber of parliament. We say Rajya Sabha is the second chamber of parliament and not secondary chamber. What is your primary role? What is your secondary role? Your primary role is that of a batsman. Your secondary role is you can be a good fielder as well. But you will be selected in the team because of your batting, because of your primary role, not your secondary role. When we will discuss legislative council, I will tell you that legislative councils are secondary chambers. They are inferior chambers. Legislative assembly has more power as against legislative councils. But we say Rajya Sabha is not the secondary chamber. It's the second chamber of the parliament. It has equal role vis-a-vis Lok Sabha. How? All constitutional amendment bills shall have to be approved by Rajya Sabha separately. Because a constitutional amendment bill, once it is passed by both houses of the parliament separately, then it can be sent to president for signature. That means Rajya Sabha and Lok Sabha, they have an equal role. All types of emergencies, whether it is national emergency under Article 352, President's rule under Article 356, financial emergency under Article 360, need approval of Rajya Sabha. What is the significance of Rajya Sabha? In coalition politics, it performs a spectacular role. And also in governments, where ruling party lacks majority in the Rajya Sabha. How? Listen to me carefully. How are these MPs to Rajya Sabha elected? By the states. So in the Rajya Sabha from Tamil Nadu, majority MPs will be from DMK. But DMK got elected few years ago. Prior to that, there was AIDMK, which had the majority in the Legislative Assembly of Tamil Nadu. So some of the MPs in Rajya Sabha are from AIADMK as well. It's a regional political party. From Odisha, majority of these MPs will be from Biju Janata Dal, which are regional political party. In Rajya Sabha, majority MPs from West Bengal will be from Mamta Didi's political party, Trinamool Congress. That means this Rajya Sabha represents states and thereby represents the regional political parties. Majority of these MPs in the Rajya Sabha from Punjab will be from Aam Aadmi Party. From Delhi will be from Aam Aadmi Party. From Telangana will be from KCR's party. From Andhra Pradesh will be from YSR Congress Party, YSR CP of Jagan Mohan Reddy. And the government, which is headed by the BJP, they have an absolute majority in Lok Sabha, but they don't have majority in Rajya Sabha. When this central government, which has this ruling party has a majority in Lok Sabha, but it does not enjoy majority in Rajya Sabha, what will the central government ruling party do? It will now bargain. And that is what we call bargaining federalism, where the ruling party at the center bargains with the regional parties to elicit support for the passage of bills in parliament. A bill has to be passed by both houses of the Indian parliament, without which it cannot be sent to the president for signature. On Delhi, there was a bill passed to nullify the judgment of the Supreme Court. All the political parties of the opposition, they decided to come together and block this bill. We will not let this bill pass. BJP was also not having majority in Rajya Sabha. BJP asked some of these regional parties, support us. So Jagan Mohan Reddy supported, Biju Janata Dal supported. So this is where the ruling party bargains with regional political parties. We have important bills to pass. We have a budget to pass. We have some important matters to pass in the parliament. We need your support. And the regional political parties will start bargaining. We will support you, but we need an All India Institute of Medical Science in our state. We will support you, but we need an IIM and an IIT in the state. We will support you, but we need assistance for our farmers. We will support you, but we need assistance in these social sector schemes. Any provision, any condition, when the center and the states, they bargain with each other, it strengthens federalism. And the Rajya Sabha is responsible for that because Rajya Sabha represents the interest of the states. And since Rajya Sabha elections are conducted in such a manner that those parties which are in power in the states, they will have more representatives in Rajya Sabha. And these regional political parties, they have a lot of members in Rajya Sabha. They bargain with the ruling party at the center for their own state's interests. It strengthens federalism. That's the beauty of Rajya Sabha. But there are others who say Rajya Sabha is inferior. Why? Because there is something known as joint sitting of the two houses. When Lok Sabha passes a bill, Rajya Sabha rejects a bill. There's a deadlock. How to resolve this deadlock? Joint sitting of the two houses. But in joint sitting of the two houses, it is the majority, it is the will of Lok Sabha which prevails. Because Lok Sabha has 543 MPs, Rajya Sabha has 245 MPs only. So whatever is decided in this joint sitting will be basically the will of the Lok Sabha because they have the numerical majority. So how can you say Rajya Sabha is the superior house or Rajya Sabha is the second house or Rajya Sabha has an equal role with respect to Lok Sabha? It does not have. But you also need to understand there have been only 3 instances since the commencement of the constitutional government in India, since the establishment of Rajya Sabha in India in 1952. Only 3 instances where we had a joint sitting of the two houses. The first was on the dowry prohibition bill. The second was on banking regulation, the repeal bill. And the third one, the last one, was way back in 2002 on POTA, Prevention of Terrorist Act. Only 3 instances in the past when we have resorted to the joint sitting of the two houses, thereby cementing the scope, the role of Rajya Sabha as an equal important house of the parliament. It is not an inferior house, despite the fact that we have something known as the joint sitting of the two houses. This is Rajya Sabha. So, what is the composition of Rajya Sabha? How the MPs to Rajya Sabha are elected? What are their qualifications? What are the special powers of Rajya Sabha? What is the significance of Rajya Sabha? Some say Rajya Sabha is significant because it is a second chamber of the parliament. All constitutional amendment bills need to be passed by Rajya Sabha separately. All emergencies that are to be imposed need to be approved by the Rajya Sabha. Rajya Sabha has an equal role to play when it comes to coalition governments, where no party has the majority, or at least the ruling party does not have the majority in Rajya Sabha. Then this ruling party starts bargaining with the center, with the regional political parties. Without the support of these regional political parties, the government of the day would not be able to carry on with its legislative agenda, cannot be able to pass the kind of bills that they want to pass. But there are others who say Rajya Sabha is an inferior house because of the provision of joint sitting of the two houses, because of the provision that it has an inferior role when it comes to money bill, which we will discuss on Wednesday. What is a money bill? And on a money bill, Rajya Sabha has a very inferior role to play. Lok Sabha has an important role. That is why Rajya Sabha is inferior. Said no. If joint sitting is the reason why you are calling Rajya Sabha inferior, then look at the instances, only three instances in the past, in the 1950s and 1960s and 2002. These were the only three instances where joint sitting was carried out, which means that Rajya Sabha has an equal important role to play in Indian Parliament. Clear? Have maximum strength of 552, existing strength is 543. Out of this 552, two were nominated by President from Anglo-Indian community. But the Constitution said, if the President is satisfied that Anglo-Indian community is not adequately represented in Lok Sabha. We discussed in Rajya Sabha there is no reservation for SCs and STs. But in Lok Sabha, there is reservation for SCs and STs. This reservation was meant for 10 years from the commencement of the Constitution. This is where many people have doubts. They assume that reservation in jobs, reservation in educational institutions for SCs and STs, that was meant to be for 10 years. No, there was no limit there. But this political reservation, where there should be reservation for SCs and STs in Lok Sabha, in legislative assemblies, this political reservation was to continue for 10 years. But every 10 years, we keep on extending this political reservation by 10 more years. There was reservation provided for Anglo-Indians also for 10 years. Who are these Anglo-Indians? These are people with British ancestry. After the independence, they decided to stay in India. They did not leave. They did not go back to Britain. So they remained Indians. They are now part of Anglo-Indian community. Constitution said if the President is satisfied that it is this Anglo-Indian community which is not sufficiently adequately represented in Lok Sabha, then the President may nominate two members from Anglo-Indian community to Lok Sabha. Which means it was not mandatory for the President to nominate these two MPs to Lok Sabha. It is mandatory for the President to nominate 12 MPs to Rajya Sabha from the fields of art, literature, science, social service. But it was not mandatory for the president to nominate two MPs from Anglo-Indian community to Lok Sabha. Why? Because Constitution said if the president is satisfied that Anglo-Indian community is not adequately represented in the administration, adequately represented in the Lok Sabha, then the president could have nominated two Anglo-Indians to Lok Sabha. But be that as it may, Anglo-Indian reservation for SCs and STs, that used to continue for 10 years, but kept on getting extended. Then came 2020, where this reservation was to end. The government decided, let's have an amendment to the Constitution. 104th Constitutional Amendment Act was passed by the Parliament. And this 104th Constitutional Amendment Act, it provided extension to reservation for SCs and STs. That means for SCs and STs, the reservation in Lok Sabha and legislative assemblies will continue. But reservation for Anglo-Indians was dropped. That means now there is no reservation for Anglo-Indians, neither in Lok Sabha nor in the state legislative assemblies. What about the remaining 543 elections take place? Elections, entire country is divided into 543 constituencies. And we will have one MP from a constituency. And this election takes place through system known as first past the post system. That means in Lok Sabha elections, how are these MPs to Lok Sabha, 543 MPs of Lok Sabha elected? The entire country is divided into 543 constituencies, which means states as well as union territories. Lakshadweep Union Territory will have one MP who was disqualified recently twice. Daman and Diu, Dadra and Nagar Haveli, they will have two MPs. Andaman and Nicobar will have one MP. Ladakh would have one MP. Delhi as a union territory will have 7 MPs. But Uttar Pradesh as a state will have 80 MPs. Bihar as a state will have 42 MPs or 40 MPs. Maharashtra will have 42 MPs. Karnataka would have 26 MPs. Madhya Pradesh would have 29 MPs. Rajasthan would have 25 MPs. So all these states and union territories are divided into 543 constituencies. And we will have one person elected per constituency through a system of first past the post system. That means you don't have to get majority. You just have to win by getting the highest number of votes. That is how these 543 MPs are elected to Lok Sabha. And their term is 5 years. But even before 5 years, you can resign or you can be disqualified, or the Lok Sabha itself can be dissolved, which we will discuss day after tomorrow. But what is the qualification in order to become an MP of Lok Sabha? You should be the citizen of India, must have completed 25 years of age, registered voter in any parliamentary constituency. For example, Mr. Modi is a registered voter in Gujarat, but represents Varanasi from Uttar Pradesh in Lok Sabha. Plus, you should not be holding any office of profit. You should not be holder of any office of profit. These are the qualifications. Now let's look at Lok Sabha and Rajya Sabha together. Because even if you are qualified, you should not come under disqualification. Listen to me carefully. We have some time? No, we don't. So we will leave it here. I'll take your questions, whatever questions you have. We will meet on Wednesday. We'll discuss the disqualifications and then the entire chapter of Union Legislature. It will take a few days, but we will cover it completely. Whatever questions you have, tell me. Sir, why and how can state governments transfer these IAS officers? Where is that question? Within the state, if that is what your question was. Yes, because the local day-to-day activities will be under the supervision of the state. So the state can maximum transfer you or suspend you, but state cannot dismiss you from the service, remove you from the service. But sir, in 42nd Constitutional Amendment Act, number of seats in Lok Sabha cannot be changed. Then how can we remove 2 Anglo-Indian seats? You cannot increase the number of seats. The number of seats still remain the same. 552 is the strength. You can't increase it. You just have stopped providing Anglo-Indian reservation. Just like if 552 was the strength, but even then elections took place only on 543. In Rajya Sabha, if the maximum strength was 250, but even then the existing strength was 245. You can't increase, but you can limit it. And 2 nominated in number. And for 1,000 people, we should not provide 2 reservations, 2 seats as reserved in Lok Sabha. Once the census exercise is carried out, then delimitation takes place where we increase the number of seats based upon the population. So it is not an arbitrary number. And why Rajya Sabha is a permanent house? Because we need one house to be permanent. Because we need one house to get the kind of business transacted in the parliament. And we will discuss that on Wednesday. Why Rajya Sabha should remain permanent. To assemblies that all UTs are not represented in Rajya Sabha, or is it there any particular reason why UTs are not represented in Rajya Sabha? What is Rajya Sabha? Council of States. What Rajya Sabha does? Protects the interests of the states in parliament. It is these states which share federal relationship with the union, with the center. Who are these states which share federal relationship with the center? States with legislative assemblies, not UTs. But in Rajya Sabha, we also include those UTs with legislative assembly. Amba need to amend the constitution with at least half of the states. Now, if you want to increase the strength of Rajya Sabha, then you need to amend the constitution. Then states ratification is required, not for Lok Sabha. On the BJP or the Congress, the case is on the union government. Maybe the position of the union government on this case will change. Let's say if the case was filed against the union government, asking the union government, please tell us why should you not legalize same-sex marriages. BJP's position was that we will not allow it. If tomorrow BJP changes and Congress comes to power, Congress may give a stand before the Supreme Court saying we allow, we want, we appreciate same-sex marriages. Court will accordingly give a different verdict because the government has allowed it. Not less than 1/3 seats in Panchayati Raj institutions shall be reserved for women. Till no. At 7 o'clock, I gave you certain questions, an assignment. Nobody could complete. I will walk out. I'll say I will not continue with the class. I'm walking out. Same goes in parliament. There are MPs belonging to different political parties. Opposition MPs, they're asking the speaker, please give us the permission. We want to speak on important matter. Speaker is not giving them permission. Or whenever the speaker gives the permission, I get to speak. The members of the ruling party, they shout at me. They don't let me complete my sentences. I will get up and I'll say, come, all the political parties, let's walk out. Let's leave the parliament. Ambarapu, please, what's your question? You're saying, sir, please answer my question. Where is the question? In your bracket, mention what is the question. Why we have restricted to only 543 MPs? Why don't we have 552? Because the need was felt that the current population that we have is satisfied by the 543 number. That is why we will have 543 elected. Clear? Passed by special majority and get it ratified by at least half of the state legislatures. Sir, Tamil Nadu has local panchayat reservation 50%. How is it possible? Reservation for women should be not less than one third of the seats. Not less than one third. It can be more than that as well. And not just in Tamil Nadu, in Bihar, in Odisha, in Chhattisgarh, reservation for women in panchayat is 50%. It should not be less than one third. It can be more than that. Old parliament. We will discuss that. Hardware is new, but software also needs to be upgraded. Just by changing the structure of the parliament from old parliament to a different parliament, hardware has changed, but it won't be of much significance unless and until the software also gets improved. Software is when MPs can debate every bill inside the parliament. When MPs may not throw chairs and microphone at each other. Where there will be thorough debate and discussion in the parliament, where each and every MP is respected. Where select committees play a very important role. And this we will discuss how the parliament is functioning right now. Sir, assembly to make laws for Karnataka. You have parliament and Rajya Sabha to make law for the entire country. Resolution of Lok Sabha. What will happen to the post of that member? Cabinet minister retires before dissolution of Lok Sabha. Retires in the sense, you can't retire. You can resign. Retire means there is no retirement age in politics. Sir, please define delimitation. Gunjan, we'll discuss that in elections. In elections, we will discuss delimitation. Sir, bourgeois means capitalist class. Resignation means if your term was for 5 years or 6 years, for example, Rajya Sabha, you resign after 2 years. Fresh election will be conducted on that seat. Let's suppose, for that matter, we had 3 vacancies from Delhi. Clear? 3 vacancies got filled, and we have 3 MPs from Aam Aadmi Party in Rajya Sabha. Let's suppose tomorrow election takes place in Delhi Legislative Assembly. Out of the 70 MLAs in Delhi, I think this explanation will make you understand better. Out of 70 MLAs, once the election took place, 40 belong to BJP and 30 belong to Aam Aadmi Party. Now, which political party is in power? BJP. There was one MP of the Aam Aadmi Party in Rajya Sabha who now resigns, saying, I don't want to continue. Why? Because he wants to join the BJP. And BJP wants its own man in Rajya Sabha. What this MP does, he resigns. He still has 4 years left, but he resigns. He joins the BJP. Now BJP sets him up as the candidate, and he will get elected to Rajya Sabha. How? Total number of MLAs, 70. How many vacancies do we have? 1 plus 1 plus 1. That means 70 divided by 2, 35. 35 plus 1, 36. Whoever gets 36 seats will be elected. That means BJP candidate would be elected to Rajya Sabha from Delhi. Total number of MLAs divided by vacancies plus 1 plus 1. So you don't retire, you resign. So when I said in 1954, one-third MPs were made to resign. So that once they resign, they will get elected again, but now their term will be for 6 years. So that their term is different from other MPs, other two-third MPs. Then in 1956, one-third more members were made to resign. When they resigned, now their term, now the election took place, now their term is for another 6 years. But this 6 year term is different from others. So one-third seats will have a different 6 year term, one-third seats will have a different 6 year term, the another one-third seats will have a different 6 year term. If both are same, why do we need both articles mentioned in the Constitution? To avoid any confusion later on, you have to be absolutely clear. Absolutely clear. We have given you a schedule that in these 25 classes we will cover Indian polity. In the schedule itself, it is mentioned that tomorrow on 24th of October, there will be a holiday on the account of Vijayadashmi. I mentioned that in the schedule itself. But thrice in the class today, I have reiterated this, repeated this, just to avoid any confusion. So that tomorrow people are attending the class, they're waiting for the class, there is no class, you will send a mail. Why there is no class? Is Sarmat sir alive? When did he die? To avoid that confusion. Similarly, if parts are different, part 3 talks about fundamental rights. Who is the state against which your fundamental rights cannot be violated? Cannot violate your fundamental right. That definition is given by Article 12. But then we came to another part 4 of the Constitution, directive principle. What is the meaning of the state? You have to tell it, explain it, explicitly mention that the definition is same as that of Article 12. There is no change. So state remains the same. Otherwise, there would have been confusion. Tomorrow, the matter would have been in the court. Sir, in directive principle, state is different. In fundamental rights, state is different. Why? Because fundamental rights are enforceable. DPSPs are not enforceable. Then it was for the court to decide what is the meaning of the term state. To avoid that, it was mentioned that definition of the state is same as that of Article 12. Shankar and Rajya Sabha will come. They will mark their ballot paper in the ballot box, and then it will be counted. Point setting, but will we agree that it is inferior in terms of money bill? Yes, you're right. Ratification means pass a resolution by simple majority. Let's leave it here. Let's meet on Wednesday, 6 o'clock in the morning.